Chief guest, Justice Syed Mansoor Ali Shah, Senior Peone Judge of Supreme Court of Pakistan, Honorable Judges from Supreme Court and High Courts of the region, Excellencies from UN Women and European Union, esteemed judges from the District Judiciary Pakistan, delegates and participants, Assalamu alaikum. I request the team FJA and UN Women to please join me on the stage, and to the participants to please rise from your seats in the honor of our national anthem. We formally start this occasion with the recitation of the Holy Quran. I would like to request Ms. Aisha Sadiqa to enlighten us with few verses from the Holy Quran. Ms. Aisha Sadiqa.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم يا أيها الذين آمنوا لا يحل لكم أن ترثوا النساء كرها ولا تعضلوهن لتذهبوا ببعض ما آتيتموهن إلا أن يأتين بفاحشة مبينة وعاشروهن بالمعروف فإن كرهتموهن فعسى أن تكرهوا شيئا ويجعل الله فيه خيرا كثيرا وإن أردتم استبدال زوج مكان زوج وآتيتم إحداهن قنطارا أتأخذونه بهتانا وإثما مبينا وكيف تأخذونه وقد أفضى بعضكم إلى بعض وأخذن منكم ميثاقا غليظا. In the name of Allah, the most kind, the most beautiful, the most merciful. O you who have believed, it is not lawful for you to inherit women by compulsion, and do not make difficulties for them in order to take part of what you have them unless they commit a clear immorality, and live with them in kindness. For if you dislike them, perhaps you dislike a thing, and Allah makes therein much good. But if you want to replace one wife with another, and you have given them great amounts of gift, do not take back from it anything. Would you take in injustice and manifest sin? And how would you take it while you have gone in unto each other, and they have taken from you a solemn covenant? Sadaqallahul Azim.
Thank you, Ms. Aisha. On behalf of the Federal Judicial Academy and UN Women, it is with great pleasure and utmost honor that we welcome you all to the Regional Inclusive Justice Symposium South Asia. This symposium stands as a beacon of collaboration and commitment towards advancing inclusive justice across our region. We will engage in insightful discussions, exchange knowledge, and explore strategies to bolster gender equality, enhance legal protections, and foster a more inclusive judicial framework. Your presence here today underscores our collective dedication to promoting justice that leaves no one behind. We look forward to productive deliberations and meaningful outcomes that will shape the future of justice in South Asia and beyond. Mr. Hayat Ali Shah, the Director General of the Federal Judicial Academy, is a distinguished leader in the realm of judicial education and reform. With a career dedicated to enhancing the capacity of the judges across Pakistan, Mr. Shah has played a pivotal role in implementing comprehensive training programs aimed at fostering judicial excellence and inclusivity. Under his leadership, the Federal Judicial Academy has seen significant advancements in judicial training and development. Today, he will be delivering the welcome address on behalf of Federal Judicial Academy. Please welcome with me Mr. Hayat Ali Shah, the Director General of the Federal Judicial Academy. Thank you.
Bismillahir-Rahmanir-Rahim. Honorable Justice Sayyid Mansoor Ali Shah, Senior Plenary Judge, Supreme Court of Pakistan. Honorable Judges of the High Courts, Honorable Delegates from South Asia, Honorable Members of the District Judiciary, respected members of the UN Women, Excellencies, ladies and gentlemen. Good morning and a very warm welcome to the Regional Inclusive Justice Symposium-South Asia, organized by Federal Judicial Academy in collaboration with UN Women Pakistan. It's a great honor to have you all here today at Islamabad for this significant event focusing on women inclusion in justice system. Our symposium is testament of our collective commitment to fostering dialogue, sharing knowledge, and enhancing judicial practice to promote women's rights and inclusivity within the justice system. Over the next 2 days, we will engage in meaningful discussion and explore strategies to overcome barriers that hinder women's full participation in our legal system. Our discussion will not only highlight the challenges, but also explore promising practices for meaningful inclusivity through structural interventions. We will learn from regional perspective and global experts, identifying ways to empower women in justice system through comprehensive capacity enhancement efforts that include trainings, research endeavors, and international collaboration. I am confident that the distinguished women judges and experts gathered here will contribute to a rich exchange of ideas and experiences. Your participation underscores the importance of this cause and your dedication promoting a justice system that truly reflects the diversity and aspirations of our society. As we embark on this journey together, Let's commit to actionable steps that will foster a more inclusive environment, ensuring that our justice system upholds the values of fairness and equality. By doing so, we will not only strengthen the integrity and capacity of our legal institutions, but also advance the principles of justice for all. Thank you for being here. I wish you all a productive and inspiring symposium. Thank you very much.
Thank you so much. Now I have the honor to invite Mr. Lansana Vune for the opening remarks on behalf of UN Women. Mr. Lansana Vune is a representative of UN Women Pakistan. His responsibilities include governance, economic empowerment, and women's participation in politics, peace and security initiatives, humanitarian aid, and combating violence against women. Previously, he held roles at UN Women in South Sudan and the World Food Programme, focusing on food security, livelihood, and joint programs with the governments. Thank you so much. Mr. Lansana Vune.
Bismillahirrahmanirrahim. Assalamu alaikum. His Lordship Justice Mansour Ali Shah, distinguished judges present here, distinguished colleagues from UN Women, international delegates, distinguished ladies and gentlemen, I bring you very warm greetings from UN Women. At the outset, I want to say that I'm very proud and feel very privileged to be standing here this morning on this particular occasion. But let me start by congratulating the Federal Judicial Academy, but also the cheerleader from the UN Women side, Madam Shamila Rasool, who is also present here, for charting the cause that has brought us here together. You will all agree with me that perhaps the greatest challenge that we face globally, but specifically in this region, is gender inequality. And one of the limitations on the potentials of women and girls is in access to justice, realizing their rights. And when your rights are limited, then you are not able to deliver your full potential. And that affects our well-being in the homes, our livelihoods, but also the national economies. And that is why we feel that this partnership is particularly important, because it is taking away that barrier, or is intended to take away the barrier that will enable women and girls to bring in their full potential to the development of their countries, but also allow them to benefit from the development processes. And that is why I've had the opportunity to work in many parts of Africa, specifically South Sudan, and importantly in Nigeria, that has similar Islamic cultures as Pakistan. I'm pleasantly surprised that the judiciary in Pakistan is so open to this kind of partnership and is ready to promote the rights of women and girls. And through this symposium, we have expanded the barrier. The frontier is expanded to making sure that it is not only about Pakistan, but it is about a sub-region. Because what is good for Pakistan must be good for Nepal, must be good for the other countries that are present here, because that is the essence of regional integration. And if the women in this region realize their rights, then this region truly becomes perhaps one of the best globally. I know today we have distinguished personalities, leaders in the profession, who will be discussing perhaps what the challenges are to inclusive justice, and in this case, particularly gender inclusive justice. when we talk about gender inclusive justice, it is about women realizing their rights, and those are right holders, but also women being integrated fully into the justice system to become the duty bearers. Many countries are making progress, but the statistics today still show that the proportion of women who sit on the bench are relatively fewer. Distinguished ladies and gentlemen, I want to specifically thank Justice Mansour for his leadership, but also within 4 months, I have been able to recognize not only his passion, but his intellectual drive in this area. And we want to follow that leadership to make sure that we deliver not only Pakistan, but the rest of the sub-region that can collaborate with us to make sure that the rights of women and girls are fully recognized and realized, and justice is delivered to them. And in this case, inclusive justice goes not only for women, but also other minorities and other population groups that do face challenges. As we meet here today, we are discussing perhaps the most important thing that will make Pakistan and the rest of this sub-region truly dynamic economies. If we can set the proper stage here, I think we will have a global ripple effect. Perhaps symposiums of this nature may have been held elsewhere, but one in which UN Women has collaborated with the judiciary, as far as I know, this is the first time. Yesterday, I had the opportunity of interacting with the Chief Justice, and perhaps that is where I've had my first opportunity. 1 week in Pakistan, I had the opportunity to meet the Chief Justice of Pakistan. I have never seen that anywhere. I was in Nigeria for 6 years. Even though I have a partial background in Nigeria, I never met the Chief Justice. In South Sudan, I never met the Chief Justice. Here, I have met the hierarchy of the judiciary from the Supreme Court to the High Court. And I think that shapes the narrative for Pakistan. Before coming to Pakistan, the understanding is that it's a conservative country, and therefore every man here is a conservative man. But there we saw the Chief Justice. The first time I met him, he was actually quoting from the Quran, the rights of women. And so are so many other judges in this country. And I think this is a good sign. And therefore, Pakistan, I think, is the right place to have this kind of symposium. Not only to tell the world that what they get in the media is different, but also for Pakistan to share with other countries the good practices that we have here. I will take that back to Africa, and I believe the international delegates will not only share their good practices, but will also take away what is good in Pakistan to be multiplied in their countries, to be adopted in their countries. On this note, let me profoundly thank the Federal Judicial Academy for sustaining this partnership, and let me also commit UN Women's Partnership going forward. We are committed, we are trustworthy, we want to deliver justice inclusively in Pakistan and beyond. Thank you very much.
Thank you so much, Ms. Nansana Wane. Justice Syed Mansoor Ali Shah, Senior Pune Judge at Supreme Court of Pakistan, is a luminary in the field of judicial reform and human rights. Before going forward, I would like to say thanks to Justice Aisha Malik for joining us. Welcome, Justice Aisha. Justice Mansoor Ali Shah is known for his progressive judgments and commitment to justice. Justice Shah has been a steadfast advocate for judicial transparency, accountability, and inclusivity. His work has significantly impacted the legal landscape in Pakistan, particularly in advancing gender justice and promoting a more equitable judiciary. I would like to refer some of his golden words in remarkable judgments. As Justice Shah ruled in Uzma Naveed, it is time to bid farewell to gender biases and prejudices, and pave the way towards the actualization of these robust and unwavering constitutional ideals and values by embracing the participation of women in all spheres of life with honor and dignity. In Atif Sharif, he says, "Right to dignity is the crown of fundamental rights under our Constitution and stands at the top, drawing its strength from all the fundamental rights under our Constitution and yet standing alone and tall, making human worth and humanness of a person a far more fundamental a right than the others, a right that is absolutely non-negotiable." Today, Justice Shah will deliver the inaugural speech, setting the tone for our symposium and inspiring us with his vision for a more inclusive and just legal symposium and system in South Asia. Thank you so much. Please welcome with me, with a round of applause, for Justice Mansoor Ali Shah.
Thank you, Shazia, for those gracious remarks of yours. Ladies and gentlemen, Assalamu alaikum. Before I start, special thanks to UN Women, in particular the two energetic people behind, the leadership behind the UN Women in Pakistan, Lasana Wone that you just heard, and Sharmila Rasool, she's also there. The best part is that their hearts beat with us in Pakistan, and that's the wonderful part, you see. And I found them more Pakistani than anybody else. But thank you for being here with us, and thank you for putting this all together for us also. Thank you to the FGA team, the wonderful team under the leadership of our Director General, Hayat Ali Shah, who's done a wonderful job. And I hope that this partnership continues, and we get to make a difference eventually on this particular issue of inclusivity, which we'll talk about today. So let me just start off by, I think there was no better starting point than referring to Cornelia Sorabji, who was a pioneering figure in the history of women's rights in India and a trailblazer in the legal field. Born in 1866 in Maharashtra, India, she was the first woman to graduate from Bombay University. Despite facing significant opposition due to her gender, she won a scholarship to study at Somerville College, Oxford, becoming the first Indian woman to study at any British university. And I quote from her, and that's the starting point for today. So Cornelia Sorabji says, "I've never asked for concessions to my sex. I've only ever asked for equality." And that kind of sets the tone for this entire discussion that we're going to talk about. So inclusive justice, in its broadest sense, would refer to a concept aimed at ensuring that everyone, regardless of their background, identity, or status, has equal access to justice. That everyone should be treated equally under law and without any discrimination based on race, gender, age, disability, socioeconomic status, or any other characteristic. But today, we talk about inclusive judiciary, which is one that reflects diversity of the society it serves. But more particularly, we talk about today about a gender-inclusive judiciary, or a gender-equitable judiciary, or more precisely, a women-inclusive judiciary, which focuses specifically on increasing meaningful representation and valued participation of women within the judicial system. So that's the focus, because inclusivity talks about a number of other factors. Let's just home in on bringing women into picture, into the justice system. So this approach is often motivated by a historical underrepresentation of women in the judiciary and seeks to correct this imbalance. And that's what we want to focus in the next 2 days, please. So it's important to understand, and I think this is something that we need to really share and understand, the terms equality, the term equity, diversity, and inclusion. And it's important to set it out in the beginning before we start the day. So equality actually refers to the principle that all people are equal and should be treated equally. In the modern context, equality has come to mean treating every person identically. It means providing the same level of opportunity and assistance to all segments of society, such as in rights, status, and opportunities. It seeks to ensure that everyone gets the same things in order to enjoy full, healthy lives. It assumes that everyone starts from the same place and needs the same help. For example, in a classroom setting, equality would mean giving every student the same textbook. Equality does not necessarily involve trying to compensate for historical or social disadvantages. Then comes equity. On the other hand, equity involves recognizing that people start from different places and therefore may need different resources or opportunities to achieve similar outcomes. Equity is different from equality because it argues that treating people identically is not always just or fair. In the classroom example, equity would mean providing additional resources like tutoring or special accommodations to students who need them to reach the same level of understanding as their peers. Some people are more advantaged than the others, and fair treatment should be about taking these differences into account to create a level playing field. Equity is the principle that justifies affirmative action and positive discrimination. People should be treated unequally if that is what is needed to attain more equal outcome. Then comes the word diversity. Now, diversity refers to the representation of individuals with diverse backgrounds, perspectives, abilities, and traits in an organization. Diversity is simply about having different identities present at the table. It is inclusivity or inclusion that makes the presence meaningful. So inclusivity or inclusion then refers to actions and strategies of organizations aimed at making their diverse members coexist and getting the best out of them. Hence the inclusivity conference symposium here. It is about how employees feel at the workplace and the extent to which employers embrace them and allow them to make a meaningful contribution. I am of the view that equity and equality are inbuilt in inclusion. Inclusion is therefore a more wholesome version of equality, equity, and diversity. Werner Myers is a highly respected thought leader. Anybody who hasn't read her, please do. One of the thought leaders for inclusivity and diversity, a speaker, author, and a consultant. And I quote her. She says, and this actually sums it up and explains things very clearly. Diversity is being invited to the party. I repeat, diversity is being invited to the party. Inclusion is being asked to dance. So that's the difference between diversity and inclusion. So inclusion is far more wholesome, and that's what we need to move forward to. Another thought leader in the area is Jennifer Brown, a speaker, an author, and Brown's work focuses on leadership and inclusion in the workplace. She says, diversity is the who and what, inclusion is the how. So that's how we, actually actualizing diversity is inclusion. So why a gender equitable judiciary or a women-inclusive judiciary is important. Now, Brenda Hale, who's also a friend but also former president of the UK Supreme Court, says, a judiciary composed only of men is not properly constituted judiciary. It is missing something important, and that's certainly women. So, why do we need to rethink the way we're working? And I'll come to the figures and statistics which are appalling, but I'll come to that later. But why do we require women in our judiciary? Why do we require a women-inclusive judiciary? Why do we need a gender-equitable judiciary? Because there's a new perspective that the women bring, one of the factors. Women bring different life experiences and perspectives to the bench. And I've experienced that sitting with Justice Aisha, frankly. I have felt that in a number of cases I've learned a lot because that's the perspective that's come on the bench. And Earlier I thought this was just a theory, but no, I actually realized that. Which can enrich judicial decision-making. Diverse perspectives help ensure that judiciary reflects the society it serves and can lead to more thorough and nuanced interpretations of the law. Their presence can influence the development of jurisprudence in areas affecting women and children and beyond, and beyond. Let's not limit women judges to family laws and family matters. They go beyond that, please. I mean, there's a general understanding that a female judge ought to be given family work. That's not correct. We need to move beyond that. I think that deserves a clap, actually. Just to lighten the mood a little. The second real important factor would be fair representation. Women make up approximately half of the population. I'm coming to the figures in a bit. So their representation in the judiciary helps achieve a gender balance that mirrors society's demographic structure. This representation is crucial for the legitimacy and credibility of the justice system itself. Role modeling. Female judges serve as a role model and inspire women and girls to pursue careers in law and other fields traditionally dominated by men. And I'm thankful to the women in law here who've done a wonderful exhibition, which you might have seen, which is being displayed at the Federal Judicial Academy. I mean, that's the kind of work we require, that's the kind of networking, and that's the kind of awareness programs that we need to do. And I want to thank Nida Usman sitting here, who's been a person behind it. So their presence can help break down gender barriers and promote gender equality within the legal profession. Then, enhanced public confidence. A judiciary that reflects the diversity of the community it serves can enhance public confidence in the legal system. People are more likely to trust and feel fairly treated by a system that includes judges who share their gender, cultural, or ethnic backgrounds. It is also a promotion of equality. By actively promoting gender diversity in the judiciary, the legal system reinforces the importance of equality and non-discrimination, principles that are foundational to democratic governance and the rule of law. And I refer to Sandra Day O'Connor, the first US Supreme Court judge, and I quote, "Society as a whole benefits immensely from a diverse judiciary that includes fair representation of women who constitute more than half the population." And Audre Lorde, an influential American writer and a feminist, and I quote, "It is not our differences that divide us." This is a wonderful quote, and I want you to pay attention to it. And she's a wonderful writer. I'm sure you've heard of Audre Lorde. "It is not our differences that divide us. It is our inability to recognize and accept and celebrate those differences." And I think that also sets the tone. Now I'm getting into a rather depressing area, the statistics of Pakistan. So bear with me. Pakistan has a population of 243 million, while women make 49.56% of it, which is almost 50%. According to the Global Gender Gap Report 2023, World Economic Forum, Pakistan ranks 142nd out of 146 countries, making it the fourth lowest globally in terms of gender parity. A significant portion of Pakistan's population is young, which is a beautiful, wonderful factor. About 64% of the total population is under the age of 30, and 29% is specifically between the ages of 15 and 29. This demographic distribution highlights the potential for a significant demographic dividend if properly harnessed through education, employment, and civic engagement opportunities. I think this moment in our history we must seize. As they say, carpe diem, this is the time to seize this moment. And we have a population and the demographics which no other country around us has. And we cannot sleep and let this pass by. This is the time to really act. So the total number of judges in Pakistan, because we just specifically in the next 2 days want to talk about how to make our judiciary more women inclusive. So according to the most recent statistic compiled by Law and Justice Commission, thanks to Rifat Bhatt sitting here, our secretary, who's been a great support in this, and my law clerk, Umar Ranja, there are 3,534 judges in Pakistan, servicing 243 million people. That itself is a problem, but I'm not going in that direction. including the Constitutional Court and the District Judiciary. 3,534 judges in Pakistan. There are 17 judges in the Supreme Court, including 2 women judges. That's 11% of women representation at the Supreme Court. Out of 143 judges in the high courts, there are 5 women judges, making their representation only 3.5% all across Pakistan in the high courts. I'm glad that our judge from the Supreme Court is here and one of our judges from the high courts is here. Thank you for being here. Out of the 3,374 judges of the district judiciary, 562 judges are women, making their representation only about 17%. So we're talking about 11% at the Supreme Court, 3.5% at the high courts, about 16.65 or 16.7% in the district judiciary, which is the real area which we need to focus. In totality, women judges make up to 16.3% of the entire judiciary in Pakistan. That's no figure if you look at your demographics. You have 50% as a population. The judges, the female judges, or the women judges in the judiciary are only 16.3%. So one vision statement that I could sort of put down on the table is that we need to take it to 50%. And that is the whole exercise. This 2 days, and I just want to hear good ideas. How do we move the 16% to 50%? That's what we need to achieve. And I want to see if there's some good ideas coming out of it so that we implement and actualize that and make Pakistan the first country which has 50% women, as per our demographics, as judges in our judiciary. That does deserve a clap. That also gives me a little break also. So just again going down at the granular level and just pointing out, very interestingly, how various provinces are also acting on this. There are 5 judges in the provincial high courts. So interestingly, Punjab, which has a population of 127 million and with a women population of 56 million, has 1 female judge at the high court. That's not very exciting. And so that's just 1 judge in Punjab, the largest province population-wise. Sindh has 3 women judges. One of them is here. And the population of women in Sindh is 23 million. So 23 million, just 3 judges. I could go to the other provinces, but I want to go to KP first. Now, KP has, and Balochistan has 0 women judges in their high courts. And the population of women in KPK is 19 million. And the population of women in Balochistan is about 6 million, and we don't have a judge in either of these 2 high courts. Not very encouraging. And of course, there are no women judges in the Federal Shariat Court. So Khyber Pakhtunkhwa also has which is very encouraging though, Khyber Pakhtunkhwa also has the highest representation of women judges in the district judiciary. I didn't know till I got the data. 126 women judges out of 504 judges, making it a 25% representation of women judges in KP, and they deserve a hand on this one. One would never really think that KP would be going in that direction. Wonderful. You just have to plug another 25%. Islamabad Capital Territory is at 23%. It's a smaller area. But Punjab, you see, one of the leading provinces, has just 17% women in the district judiciary. Sindh has 13 and Balochistan has 12. But I'm not too happy with Punjab with 17%. There are 1,738 judges and 292 women judges, which constitute 17%. In Punjab and Balochistan, there is not a single woman judge who is heading a district. Isn't that sad? In Punjab, I forget about Balochistan, there could be issues, security issues. But in Punjab, there is not a single district judge, a woman single district judge who's heading a district. Sindh has 1 woman judge heading a district, while there are 6 judges heading districts in Khyber Pakhtunkhwa. So my compliments to the Chief Justice of the Peshawar High Court They're doing a wonderful job in KP, in spite of all the challenges they're facing. Now, further depression comes in. When we talk about, we just wanted to see how women are coming into judiciary, because in the district judiciary, you take an exam and you come into the system. So just try to look at the data to see what's the kind of increase or decrease in the interest of women joining district judiciary. And it's, on a sad note, I say that in Punjab, we've seen a 75% decrease in women joining the district judiciary. In Sindh, there is a 38% decrease. In KP, there's a 30% decrease. However, there is an increase in Balochistan, for whatever figures we got, which is encouraging, but otherwise, people are just women are staying away from judiciary. They don't want to join the district judiciary, and it's kind of receding. In 2000, well, the figures, I don't need to go into every province, but that's the general statistics that we have. Coming on to the paralegal staff, 48,000 people or persons constitute our paralegal staff, which is servicing these 3,000 or so judges in the country, and especially in the district. So out of this 48,000 paralegal staff in the country, you won't be able to imagine how many women staff do we have across the country. We just have about 1,200 women, which constitutes about 2.5%. In a team of 48,000 paralegal staff, we just have 1,200 women, which is 2.5, in a population of 121 million women in the country. So with a population of 121 million in the country, we just have 1,200 women servicing all the judges, in all Pakistan, 2%. In Punjab, we just have 912 women out of the staff servicing all those judges that I talked about, and the Sindh has 59 women, KP has 208 women, and it goes on in that kind of direction, which is not very healthy and encouraging. And in the high courts, the paralegal staff, women, is just 4% of the entire staff we have in the high courts in the country. And I hope with Sana Minhas, Justice Sana Minhas there now in Sindh, and Justice Aisha at the Supreme Court, we'll have more judges, at least in our court, more female staff, paralegal staff, in our courts at least. We need to open that up. Now let me come to the Attorney General's office and the Advocate General's office. I'm sure some of you people are working for them also. So there's a total of 169 lawyers working in the Attorney General office. Out of 169 lawyers, guess how many are women lawyers? Just 19, which is 11% of the total strength. I mean, if we're not doing that well at the judicial side, I mean, come on, the Attorney General's office could have done something better, but they just have 11% of the total strength. Where are the women, I would ask? Where are the women lawyers? Why aren't they joining the Attorney General's office? What's happening? As we move forward towards the Advocate General's office, Punjab has 57 lawyers, out of which only 4 women are working at the Advocate General's office, which is 7%. I'm surprised. Where are they? And what's happening? In Sindh, there are 2 women lawyers. In Khyber Pakhtunkhwa, only 17 women lawyers, while in Islamabad, 1 woman lawyer works for the Advocate General's office. And there is no women representation in the Advocate General office of Balochistan. Prosecutors. Total strength of the prosecutors in Pakistan is 2,200, approximately, out of which there are only 340 women, so making a 15% or total of the total strength. We're just not breaking the ceiling above 16%. We're not breaking it. We're just stuck on 15 to 16%. That's the highest figure we've reached. Islamabad has the highest representation of female prosecutors, which is 22%, followed by Sindh, Khyber Pakhtunkhwa, and Balochistan. But overall, when you look at it, it's just 15%. Now let's look at lawyers in academia, for that matter. The entire supply chain. Where are the women? As far as the lawyers are concerned, there are about 39,000 or about 40,000 women lawyers in Pakistan. Out of 238,000 lawyers in the country. That would again be 17%. Are we really seriously stuck on the 17, 16%? We're not moving beyond that. Then let's go to the Pakistan Bar Council. Has a total of 5,000 odd members, lawyers, out of which 189 members are women, which is again 4%. Pakistan Bar Council, which is a regulatory body looking at this entire sector, itself does not have women, so I don't know how are they going to regulate things. Punjab has the highest number of women lawyers, that's about 17,800 or so. And out of which, women lawyers are 17,000, out of a total of 45,000 lawyers, which is also 13%. So in Punjab, I keep referring to Punjab, thinking of it as to be perhaps a province we need to showcase because of its education facilities and the budgetary requirements, but it has 13% of the strength. Yet Khyber Pakhtunkhwa, once again, takes the cake. Has the highest representation of women lawyers, that is 13,750 out of 48,000, which is 28% of the representation. And could I just request the members of the district judiciary from Khyber Pakhtunkhwa to stand up for an applaud on this one? Is anybody here for Khyber? You deserve a round of applause. And Justice Dr. Khurshid is here from the High Court. Wonderful job in KP, I must say, wonderful job. And this is a province we think, oh, there is terrorism there and there are problems there, and KP, I mean, how would that be possible? Look what they're doing. Moving on. So how do we get to 50%? That is what this symposium is about. And that's what I wanted to just say in the inaugural, that we need to set the tone on how do we move from 16, 17% to 50%. What are those strategies that we require? Where are we going wrong? So we want to get up after 2 days of deliberations with a strategy, and I would urge the organizers to have a strategy document in the end as to what are those strategies that move us forward. How do we do it? But do it we must. So some of my ideas that I want to share, which I think could move this a little, would be, number one, let's enhance the representation. The appointment process has to be rethought. How do we get them into the system? So encouraging more women to join the judiciary involves a multifaceted approach that addresses educational, institutional, cultural barriers. Here are some of the interventions. And of course, I don't need to go into the fact that, yes, everything starts at home. We would request parents sitting here to encourage their daughters to go out there and study law or study and go out to the university. Of course, we would want schools to have law subjects in them. And of course, we would like the universities which are running the law schools to be more robust, and they talk about such how to join the judiciary, and there should be mentorship or road shows there, but I don't want to go into that area. I want to come to my area, that we need to have a proper, robust, dynamic appointment policy, which we do not have. In spite of Article 25(3), we do not have an appointment policy on how do we look at this issue. We're just going on appointing people without any sensitivity at all. So in spite of Article 25(3), which says you can take affirmative action, we could just bring in more women over and above the men if we want to do that. Constitution allows us, but we're not looking at that article. So this applies to district judiciary as well as the constitutional courts. Draft rules of the constitutional courts have been framed, and they have not yet been approved. But for the first time, the concept of diversity has been brought into that, and of course that should lead into inclusion later on. But at least there's a beginning, and we see what happens if those rules go through. That would mean that we prefer a woman, irrespective of her seniority, and bring her up to a position, provided she meets the standards, and sort of that kind of an appointment policy. We need to have that factor also. Let's not confuse the fact that in a diversity or an inclusive setup, you might give preference to some women to come up. Does not mean that they cannot compete at the general seat level, which is purely on equality basis. Nobody is denying that. But in addition to that, we need to make some changes and some amendments to bring them up. So not only appointments into service, but effective representation through our judicial career, through their judicial career is also important. It's not like bringing them into service alone, but what happens later on. Like as I said earlier, diversity would mean we've got them in. I'm very happy we have some women in the system. But that's not enough. Now we need to make sure that they're meaningfully interacting with us, they're actually inclusive. We've brought them in a meaningful manner and value their presence in our system, and they're engaging with us now and doing and contributing in the best possible manner that they can. So just bringing them in is not enough. I've heard people say, oh, we've got the gender balance, we've got 2 women in. But then what? You do not have systems that look after that woman when she comes in. So the representation must continue once even she joins the system. The whole culture needs to support her so that she comes out and gives out the best to the system. So that is important. We cannot stop. And we have appointments and other positions, and we need to make sure that they move on to higher positions. Like as I said, nobody is heading a district judiciary in Punjab. Very sad. There are no district judges in Balochistan and one other province that I mentioned. So, this is not right. However, we have good stories. We have the registrar of the Supreme Court, she's a woman. We have the secretary of the Law and Justice Commission, she's sitting here, Ms. Rifat Bhatt. That's an encouragement. And we, of course, have these fantastic female judges who are at the Supreme Court, at the high courts, and wonderfully, things are happening in that direction, but we need to add to that. So, let me just refer to Ruth Ginsburg here in a quote from her, that women belong in all places where decisions are being made. And that's not something we're understanding. We set up committees, we say, okay, these people can do it. Oh, this is a building matter, okay, you do it. But it doesn't come to our mind that, a woman could also be doing all that. And we need to make sure that the district judiciary, at the high courts, at the Supreme Court, you set up committees. There are committees for administrative work. Every committee must have a woman, maybe headed by a woman. And you see the results. And I assure you they'll be better than the ones that you've seen so far. So that's what Ginsburg is saying. Women belong in all places where decisions are being made. It shouldn't be that women are the exception. And that's the kind of thought that we need to bring in. We need to also bring in awareness campaigns, programs that highlight the achievements of female judges and the importance of gender diversity in the judiciary can inspire women to pursue judicial careers. And I think this exhibition at the FGA would be in that direction. And I'm fully supportive of it, and I would urge everybody to go and visit that exhibition. I haven't done that, but I'll do that today. But everybody should do that. Then the mentorship programs could be considered. For example, establishing a mentorship program where experienced female judges mentor young female law practitioners can provide guidance, encouragement, career advancement opportunities, and events like this, the UN Women's commendable work, would be wonderful, you see. So we need to start engaging. We can't just sit in silos and imagine that 17% is going to move to 50%. I think our female judges ought to take up a rather more robust and a more proactive role of going out, and I'm quite sure that they are doing that, but they need to take that role of mentorship, telling people how you can come into judiciary and make a difference. Because I don't think a lot of lawyers understand that joining the judiciary could make a huge difference, which you can't as a lawyer. And I say that because I was a lawyer earlier. I think I can make a huge difference sitting here. My contribution could be immense, simply multiplied by being a judge. I could never do that or achieve that kind of a result or outcome as a lawyer. So young lawyers sitting here, please consider judiciary and think about it. You can make a difference and the country would develop. Policy formulations and implementations are important. We need to develop and implement policies that promote gender equity. I haven't seen a policy in my judicial system which does that. We did some work on transfer policy in Lahore, but our transfer policies need to be gender sensitive also, which I don't think they are very much. Such equal opportunity policies, anti-harassment policies, and parental leave policies, a number of things that we need to think about which affect women, which could make life much better. Monitoring and evaluation systems aren't there. For example, establish systems to regularly monitor and evaluate the effectiveness of the gender policies, once we have one, and training programs using feedback to make necessary adjustments. There has to be a constant, it's a living and organic document that we see how changes can occur. We need to have an organizational cultural change. launch campaigns to raise awareness about the importance of gender diversity, such as like this, and inclusivity within the judiciary. We need to constantly do that. And of course, encourage the involvement of women in all decision-making processes, which I mentioned earlier, in the development of policies also. We need to also think of professional networks, and now women in law and others, Kanundan and others come in the picture, who are the support systems that work with the judiciary and promote creation of networks for women in judiciary, which is wonderful. And I think we need more of them to talk about this, because we're all busy working, and these networks around us bring in a lot of, share a lot of experiences, do a lot of good awareness. And I pointed out that these two organizations, a number of others, who are doing a great job on this. So a number of countries who are doing wonderfully well could be looked at. For example, Canada. And I recently had a chance to visit the Canadian Supreme Court, and I was, so impressed. I went and sat in court 1. They just have one court, and they all sit en banc, so one court, and 9 judges. And out of 9 judges, 5 were women. I just could not believe that. 5 judges were women in Supreme Court of Canada, out of 9. The poor Chief Justice had women all around. Not poor, but I mean very happy Chief Justice. So that was interesting, and I think that's the kind of thing we need to do. And I went into the gallery, and I saw Beverly McLachlan. She was the longest-serving Chief Justice in the world, perhaps. She was there for 17 years, from 2000 to 2017, and one of the ablest of judges also. She's written some wonderful judgments. And she was there, the Chief Justice in Canada, for 17 years. So, I mean, there are examples, and we need to follow that. So Scandinavian countries would be another example for anybody who's looking into this, and especially the FGA and UN Women to, let's look at Scandinavian model also and see how they're doing it. South Africa is doing a wonderful job, United States itself, Australia. I don't need to get into the policies they've done, but they come out as the leaders in the area, United Kingdom also. So that's one. Then structural changes are required, which I would like to underline. We need to move beyond symbolic gestures of diversity to enact deep structural changes that foster inclusive environments. This thing goes a bit unaddressed. We're not really sensitive to this. Do we have a toilet for women around? No, not an issue. That's not a main issue for us. But I think men here need to start thinking about these things, that how does a woman, operate? And we need to understand that. So you need to be a woman to understand this. Think of it. All men, please think that you're a woman, and then you're making a policy, and that would probably make things better. So create a more inclusive environment for female judges. Structural accommodations and thoughtful design considerations are crucial. These accommodations not only ensure comfort and privacy, but also signal a commitment to gender equality and inclusivity. Here are some essential structural accommodations that come to my mind. Separate restrooms, for example. We haven't really got to the unisex thing, but separate restrooms. Provide separate, well-maintained restrooms for women. These facilities should be easily accessible and offer privacy and security. And I think I visited some of the districts in Punjab, and I tell you the situation is appalling. A woman judge, a female judge, will have to get out of a court, walk through the complex, the entire judicial complex, and probably get to some corner somewhere to use a toilet. I mean, how would you feel doing that as a judge? You get up, you don't have a restroom next to your court, and you're just walking by and going somewhere else. And there are a number of other issues attached to it. We talk about changing rooms, nursing areas. There could be private changing rooms for female judges, which are especially useful for those who might need to change into judicial robes. I mean, do we ever think about that? No. They'll come and do things on their own. Nursing rooms, there could be mothers who are nursing mothers dedicated to lactation, and rooms that are secure and comfortable can make significant difference. These rooms should have facilities for storing breast milk, comfortable seating, hygiene facilities. I mean, some of you might be just saying, oh, what is this? What's going on? But this is required. This is required. Security measures, enhanced security measures to ensure that female judges feel safe within the courthouse. And I tell you about Punjab, that's not so. I mean, there could be a number of things have happened at the bar level also in Punjab, and they're not safe. I mean, look at the court structures themselves, the way they're sitting. They're practically sitting on the road. Some of the female judges go look at the districts in Punjab. I have experience in Punjab, that's why I refer to Punjab. Go see how they're sitting. They're sitting on the road practically, dispensing justice. This can include secure parking, well-lit walkways, security personnel who are trained to gender sensitivity. Do they have a staff that works with them? Do we have a female staff working with a female judge? No, we never thought about that. We'll come to that later. We just have a woman in the system, and that's enough for us now. But that's not enough. We need to go beyond that and understand that we're giving them that culture that's required. Health and wellness facilities. Do we have a gym for them? Do we have a relaxation area for them? Do we have a prayer room for them? No, we can come to that later, not relevant. No, it is relevant. We need to start thinking about this now. Office and workplace design. Design office spaces that are ergonomic and cater to the needs of female judges. No, we have never thought how a female judge would want an office design. No. This includes providing adequate office furniture that suits a range of body types and preferences. Ensure that workspaces are situated in areas that provide both privacy and accessibility to courtrooms and administrative areas. Accessible meetings and conference rooms. No, we don't think about this. Accommodation for assistants and children. No, we don't think of this. Ensure that personal assistants, if any, have adequate workspace to close to the judge, then they assist, facilitate efficient work dynamics. No, we don't think about this. So it goes on, the list goes on, and I can just talk about this in the session, then I'll talk about structural changes. The next is capacity building. Now, this alone cannot happen. You've appointed them, you need to give them more representation, you give them higher positions, you involve them in committees, you look at all the structural changes, this is going to bring them in. This is how you market, and this is how women will feel comfortable and secure coming into judiciary. Then is the capacity building. I mean, a lot of men, including myself, we need to understand all this. In order to ensure that justice system is truly equitable, fair, and gender responsive, it is imperative that both male and female judges are properly trained in sensitivity and sensibility required to understand and consider gender perspectives and understand inclusivity. I've been talking to some of the team of the ADB that did gender studies and gender program at Lahore with the judges, and I hear of some appalling stories and the kind of mindset that those instructors have communicated to me, the kind of mindset we men have in the judiciary, and that's sad. And I think we need to change that. That needs an immediate rethink. Training and education is important. I think FGA has already started programs on this, and I hope that all the other judicial academies would be looking at training, and training is important, and people need to understand, judges need to understand, the staff needs to understand how do we create that culture which is conducive for them. So the entire capacity building area is important. We need to give and make sure, and I have said this earlier, that give women leadership roles, and we need to have a program where we develop women for leadership roles. I haven't yet seen a program being offered at any of the academies, and I'm not sure if FGA does, where we train our judges from the district judiciary for leadership roles, women for leadership roles, that they will become district judges, they'll head this particular thing, they'll head that. No, I think it's all mainly men. So that's important. So I'll just, that was one area that I wanted to push and refer to. And I move on to jurisprudence. I don't want to talk much about it because that's about us. I think the Pakistani courts have come up with really robust jurisprudence promoting the rights of women. And I think the next session is all about jurisprudence. Over the course of time, the Superior Courts of Pakistan have adopted a more liberal and progressive interpretation of the law which takes into account gender-sensitive lens, paving way towards jurisprudence that is inclusive. This approach has been replicated in cases relating to two-finger virginity testing, workplace harassment, property and inheritance rights, right to vote. But I don't need to go into this and labor through this. There are courts, and there are some fantastic quotes from these judgments, very inspiring. But I think the next session is all about this, so I don't want to sort of double the exercise. In the end, you see, finally, I just want to leave you with the following thoughts, and I think that, to my mind, would be the areas that we need to be working on the next 2 days in order to develop where we're going ahead. Would be representation, would be one big area I would urge you to think about. And representation is not only just appointment, but representation later on when they are there, they keep getting promoted, they keep representing at higher positions. The second is the structural adjustments. How do we create the whole environment for them? As I said, most of the things we've talked about. Capacity building, what do we do in capacity building to ensure that we create a system where people would be interested and come into it? So in the end, I'll just leave you with Malala Yousafzai's quote, which I really like. So I raise up my voice, she says, not so that I can shout, but so that those without a voice can be heard. We cannot all succeed when half of us are held back. So please, let's move from 17 to 50%, and let's come up with the best strategies in the next 2 days. Thank you very much.
Thank you so much, Justice Mansoor Ali Shah. Now I am announcing a 20 minutes break. The venue is outside this hall. Thank you so much. We will be resuming at 11:50, I think. We'll be resuming at 11:45. It's 15 minutes break only. Thank you. Ladies and gentlemen, can I please have your attention? Ladies and gentlemen, can I please have your attention? We are resuming the session. I request that all the judges please come back to your seats. मैं पहले नंबर पे बैठूंगी। Assalamu alaikum. Can I please have your attention? Honorable ladies and gentlemen, can I please request to resume your seats? We are running short of time. I would request the chief guest and Justice Aisha to please resume the seats. Thank you so much. I am Shazia Manawar with you for the next session. Again, the UN Women Pakistan, with funding from European Union, commissioned a study report on expanding women's rights through judicial jurisprudence. For the launch of this study, I have the honor to invite Justice Mansoor Ali Shah to please come to the stage. We are inviting. I repeat, for the launch of the study, I have the honor to invite Justice Mansoor Ali Shah, Mr. Lansana Bane, Mr. Hayat Ali Shah, Justice Aisha Malik, Justice Muhammad Ali Mazhar, Dr. Samza, Dr. Rahim, Yunus Khalid, Justice Umar, Justice Umar Sayal, Justice Amir, Justice Sana, Justice Khurshid. आपने स्टडी लॉन्च कर दी. So this is a study report funded by European Union. The UN Women Pakistan is launching this study. So the launch of study takes place. Sharmila is coming. So we are waiting for Ms. Sharmila. We are inviting Ma'am Sharmila as well. Madam Sharmila from UN Women. The women inclusivity. I also invite all the foreign delegates, justices from Supreme Court and High Courts, Zarizana. So thank you so much, Justice Mansoor Ali Shah, for this idea of inclusivity and women representation. I also invite Ms. Aisha Raza. Thank you so much for allowing this, sir, because now it looks more colorful and inclusive. Thank you so much. I will request the support team to arrange the stage again. Thank you, sir. Now I would like to invite the author's brief on key findings on the study. Okay.
Uzair, Mudassir, Farhad, Salma, please come on the stage.
Thank you so much, everybody who joined us on the stage. Now, I would like to invite the author's brief on key findings on the study, expanding women's rights through judicial jurisprudence. The study includes jurisprudence on rape laws, women's inheritance rights, domestic violence, child marriage. I invite Dr. Samza Fatma, who is one of the authors and is a distinguished scholar and academic specializing in women's rights and gender studies, with a productive career dedicated to advancing the understanding and protection of women's rights. Dr. Fatma has made significant contributions through her extensive research and publications. Today, we are privileged to have her here with us, so please come to the stage and have your seat, ma'am. Dr. Muhammad Rahim Awan, the Director General of the Legal Aid and Justice Authority, is a distinguished legal expert with a profound commitment to advancing women's rights through comprehensive legal frameworks. With an impressive career dedicated to justice and legal reforms, Dr. Awan has been instrumental in developing and implementing policies that provide critical support and protection for women, particularly those in vulnerable situations. Now I invite Muhammad Khalid, Yunus Khalid, who is team leader of Rule of Law and Governance at UN Women. He brings a wealth of experience and expertise to our symposium with a distinguished career focused on promoting justice, gender equality, and human rights. Mr. Khalid has been instrumental in advancing policy frameworks and implementing programs that support inclusive development. His leadership at UN Women underscores a commitment to strengthening legal system and ensuring equitable access to justice for all. Today, we are privileged to have Mr. Khalid guide us through the wrap-up session where he will summarize key insights, address queries, and highlight pathways for future collaborations. His contribution is integral to our collective pursuit for justice and equality. Thank you. So, my mic is closed and mics are over to you.
Honorable His Lordship, Mr. Justice Syed Mansoor Ali Shah, Senior Pioneer Judge, Supreme Court of Pakistan, Her Lordship, Justice Aisha Malik, Mr. Hayat Ali Shah, DGFJA, Mr. Lansana Wone, Country Representative UN Women Pakistan, Madam Sharmila Rasool, Ms. Shazia Munawar, Mr. Yunus Khalid, our Technical Supervisor, Honorable Judges from the High Courts, Honorable Judges from the District Courts, Honorable Delegates, teams of the project, organizers of the event, Assalamu Alaikum, and a very good afternoon to all of you. I would like to briefly introduce this study and the key judgments and the key principles highlighted in this. And before moving towards that, I would like to briefly pay my gratitude to the persons who have done key contribution in this. Expanding the women's right through judicial jurisprudence is a landmark book with a significant contribution on the subject in existing literature. It explores the roles of apex judiciary of Pakistan regarding recognition and enforcement of women's rights, with a particular focus on 4 core areas, including rape, women's rights to inheritance, domestic violence, and child marriage. This book comprises 2 volumes. Volume 1 focuses on rape and women's rights to inheritance, and Volume 2 deals with domestic violence and child marriage. I pay my humble gratitude to His Lordship, Mr. Justice Mansoor Ali Shah, Senior Pioneer Judge of Supreme Court of Pakistan, who showed his trust on us for materializing this project and showcased this landmark study to stakeholders among judiciary, legal fraternity, law enforcement agencies, academia, and general public. I also acknowledge the contribution of my co-author, Mr. Muhammad Rahim Awan, DG Laja, and pay my gratitude to him for his untiring efforts and support. I also extend my gratitude to Mr. Muhammad Yunus Khalid, our technical supervisor from UN Women, our esteemed reviewers from Pakistan and the other countries, Supreme Court Research Center, and the research stream of Federal Shariat Court, whose valuable feedback helped us tremendously to improve the quality of this book many times. My special thanks and gratitude to the team of my research associates, Uzair, Mudassir, Ikra, Farhad. You guys have done tremendous job and they have been working day and night even during Eid holidays. Going forward quickly, Volume 1 deals with 13 judgments of the Honorable Supreme Court on rape cases. And in these 13 judgments, there are several new principles which have been laid out as precedents to be followed in subsequent cases in order to ensure the dignity of rape victim and to inflict punishment on rape offenders more effectively. These precedents are contribution of Honorable Supreme Court of Pakistan in the expansion of women's rights significantly. And the part 2 of Volume 1 deals with 19 judgments of Supreme Court, Lahore High Court, Peshawar High Court, and Balochistan High Court on women's rights to inheritance. And among these 19 judgments, almost 11 judgments contain new principles laid down by the honorable judges to court as precedents for such cases. And this ratio shows the seriousness of the constitutional courts of Pakistan towards enforcement of women's rights to inheritance. And the Honorable Justice Mansoor Ali Shah and the Honorable Justice Aisha Malik have done tremendous job in their landmark judgments, which we are going to refer in a while. Volume 2 meticulously explored the legal, social, and cultural dimensions of two critical and pervasive issues: domestic violence and child marriages. The analysis of the judgments of the apex constitutional courts of Pakistan highlighted the significant strides made through judicial jurisprudence while also acknowledging the persistent challenges. The details of Volume 1 will be shared with by Dr. Rahim Awan. I am wrapping up the Volume 2, which deals with domestic violence. For example, in the Shaukat Hussain versus the State 2022 SCMR 1358, court held that in instances of domestic violence, especially leading to the death of the wife, within the premises of the husband, resides the husband a burden with the heavy onus to furnish a satisfactory explanation that he was not involved in that death. The emphasis placed by various justices on burden of proof in domestic homicide cases underscores the importance of holding perpetrators accountable and ensuring thorough investigations into suspicious circumstances. In the landmark judgment in Uzma Naveed Chaudhary versus Federation of Pakistan, Justice Mansoor Ali Shah and Justice Umar Ata Bandial voiced against the stigma that in Pakistan's socio-cultural milieu, victims face significant challenges and stigma associated with voicing allegations of harassment. Hence, delayed reporting should not automatically undermine the credibility of the claims. The judiciary stressed on the effective implementation of the Domestic Violence Prevention and Protection Act 2013, and the protection of women's rights underscores the importance of legislative compliance and constitutional safeguards in addressing domestic violence. I think I am having a shorter time, so I'm briefing domestic violence and moving towards child marriages now. In child marriage, there are 16 judgments of child marriage from Supreme Court, Federal Shariat Court, Lahore High Court, Sindh High Court, Balochistan High Court, and Islamabad High Court. And among them, almost 10 cases, judicial principles have been laid down, and the most of the cases, the victims have been given relief by the honorable courts. In Musammat Shahida Parveen versus Union Council, the court of Mr. Suhail Nasser held that union councils are required to formally report child marriages under Section 9 of the Child Marriage Restraint Act of 1929, which is again a landmark contribution. In the judgment of Hafiz Abdul Wahid versus Mrs. Asma Jahangir, the court firmly endorsed the autonomy and individual agency of sui juris female Muslims emphasizing their right to enter into a marital contract independently. This ruling dispelled the notion that the absence of a wali's consent undermines the validity of such unions, thereby protecting the personal freedom of Muslim women in marital decisions. There are another two landmark judgments by Justice Dr. Sayyid Muhammad Anwar, Justice Muhammad Noor Maskanzai, and Justice Khadim Hussain Sheikh. The first one is Musammat Sakina Bibi versus Secretary Law. It's upholding the human dignity and justice in landmark judgment abolishing Savara and Vani. Savara and Vani is a type of a custom in which a female child is given into the forced marriage as a compensation of her death. The Federal Shariat Court's ruling signified a crucial advancement in aligning Pakistan's legal practices. My time is up. Only 2 minutes, I'm just wrapping up. Okay. And another one, the judgment in Farooq Umar Boja versus, actually the Savara and Vani, I want to talk about it because this is the landmark judgment in which they declared is unconstitutional and illegal and un-Islamic, and they said the Jirga's rulings are not above the law and above constitution, and child marriages are strictly prohibited in Islamic laws. And similarly, in another case, the principle of Sadhu Zare justifying the regulation of permissible acts to prevent potential harm. Basically, the judgments of the Federal Shariat Court, including those concerning the necessity of wali's consent, are binding on the High Court and subordinate courts under Article 203G of the Constitution. Therefore, it's a great contribution of Federal Shariat Court in resolving the issues where the often it was related to Islam regarding child marriage and domestic violence, and Federal Shariat Court in its landmark judgments proved that Sharia and Islam does not allow any child marriage or any type of domestic violence. Collectively, these judgments affirm the state's authority to legislate in matters of public interest and societal welfare. In concluding remarks, I wanted to just wrap up in the end that this volume comprehensively comprehends the expansion of judicial principles regarding women's rights in Pakistan. However, there are still many judgments which have to be incorporated, and because of having the scope of this limited, initially we were doing it on 40 cases, but after that UN Women has been very generous, and on the recommendations of the Honorable Supreme Court, we expanded it to the 67 judgments. And to make this study even more effective, we have to strive to make it to the accessible to the more stakeholders, so that it could go to the investigation officers, police officers, because the problem lies on the implementation of that. And we need to formulate training modules on them and train those law enforcing agencies, officials and IOs, so that we could get more benefit. And lastly, in order to get more benefit and effectiveness, this book should also be translated into local languages, particularly in Urdu, and we should circulate it to the lower level in schools, colleges, and even local female women who could actually know these are their rights and they can be enforceable. Though they have financial problems, economic problems, for that they cannot go to the courts, but obviously they should know they have these rights and they are enforceable. Thank you so much for being so patient listener, and I hope me and my team have developed a good piece of book for the effectiveness of our society and for the enforcement and recognition of women's rights in Pakistan. Thank you very much.
I request that every speaker has only 5 to 6 minutes to conclude. Thank you so much.
Bismillah ar-Rahman ar-Rahim. Honorable Mr. Justice Sayyid Mansoor Ali Shah Sahab, Senior Plenary Judge, Supreme Court of Pakistan, Honorable Madam Justice Aisha Malik Sahibah, and the distinguished guests. And I won't take the name of everyone because I got only 6 minutes. So I will quickly jump to volume 1 because it is very difficult to justify study of 67 cases in just 6 minutes. In volume 1, we have analyzed 13 cases involving offenses of rape and 19 cases of women's right to inheritance. While summarizing the cases, we have seen how honorable courts dealt with the chronic issues and the problems related to these cases. They explored the jurisprudence developed in the recent judicial precedent. The judgment reshaped the landscape of women's rights, provided redress to individual on one hand, and the other established broader precedents to contribute significantly in advancement of the gender equality and the protections of women's rights. With regard to rape, the common problem with which the honorable courts dealt with the defining rape, linguistic issues, cultural perceptions, and social norms, undermining the dignity and respect of the victim during the whole course of action, daunting challenges for the victim in the legal process, from reporting the crime to securing the conviction. The evidentiary standards, onerous burden of substantial proof on the victim, various forms of power imbalances, and worth of testimony of the victim. The approach of our honorable courts while dealing the cases of the rape, it appears that they adopted more sensitive legal handling approach, which is victim-centric, and focusing on the reducing the trauma of the victim and respect the dignity and privacy of the survivor. A reflection of the cases says, for this category, I've just chosen 3 cases, and I think I'll be wrapping it up. In the one case, the Supreme Court upheld a murder conviction of sentence, including the death penalty, relying on the modern forensic techniques and the evidence, allowing the DNA, particularly DNA test report, was deemed relevant and admissible under Article 59 of the Qanun-e-Shahadat 1984, and deemed this article as the gateway to allowing the DNA testing and the modern forensic reports admissible under the law. DNA evidence is acknowledged as a gold standard for establishing the identity of an accused, providing a high degree of confidence and considered one of the strongest corroborative piece of evidence. In another case, our honorable courts where no DNA test was available, then our courts relied upon the corroborative evidence and the testimony of the victim's statement. In this case, the court emphasized the reliability of the complainant's testimony, noting that her detailed account of incident remained unshaken under cross-examination. The court found her testimony trustworthy and credible and upheld the conviction. In Atif Zarif versus others, the Honorable Court adopted the principle that dragging the sexual history of a rape survivor is a violence of the constitutional rights. Question about the victim's character lacked legal relevance. The two-finger test as a yardstick is violation of the victim's fundamental right. The court also upheld the court condemned the use of two-finger as the virginity test, highlighting their lack of scientific validity and violation of the victim's right, emphasizing that such tests have no bearing on determining sexual assault and violence of the victim's dignity. Similarly, with regard to the judicial safeguards to the woman's right to inheritance, our courts pointed out problematic practice of the gift deeds and practices of ousting women from inheritance rights, dubious oral gifts, fraudulent transfers, exclusion of women from the right to inheritance property, opacity and unfair practices in inheritance process. The court adopted the approach ensuring mandatory registration and inheritance claims and oversight by the relevant authorities. Also directed the importance of primary evidence in validating gift deeds, and where the primary evidence was not available, not only the Honorable Supreme Court of Pakistan declared that void, but also imposed penal liabilities upon the revenue authorities as well as upon the person who was claiming the right on the basis of that. They also ethical obligation of legal practitioners and held that legal practitioners are, it is accountability of revenue authorities in inheritance dispute, and the legal practitioners should not support this kind of cases where there are attempts to affect the inheritance rights of the people. In another case, the Honorable Court, in its landmark judgment, declared that the appellant perused the right or to inheritance property from a paternal grandfather. It was a very landmark judgment where a female approached the Honorable Court for the inheritance right of from her deceased father and claiming inheritance from the grandfather's property. The Honorable Court declared that acceptance and delivery of gift, Islamic jurisprudence mandates that for a gift to be legally recognized, it must encompass an explicit declaration by the owner, accepting by the donee, and the actual delivery of possession. And by relying on this, and the Honorable Court also held the onus to prove the validity of gift lies on the beneficiary, particularly in the cases affecting inheritance rights. Essentially, of unambiguous evidence in gift disputes, particularly when such transaction intersects with the inheritance matters. By these way, the Honorable Court has protected the rights of the woman, especially in the cases of the minors, where they were not able to defend their cases or produce their evidence. The onus of proof was shifted upon the beneficiaries, and this is how the Honorable Courts protected and ensured that females get their inheritance right, and it is un-Islamic to oust them from their inheritance rights. These are some findings which I could conclude in 6 minutes, sir.
Thank you very much, Dr. Saab and Dr. Samza. Honorable Lordship Justice Mansoor Ali Shah Saab, let me explain that how this study began rather than wrapping up, because it is a beginning to an end in itself. We were meeting His Lordship Sharmila Rasool, my country representative, myself, and our deputy at that time, and we were discussing certain things and the precedents of the courts. Then the bench book issue came and it surfaced there, and we came up with the idea, why not to go ahead with the 4 laws UN Women has committed to implement in Pakistan, because UN Women has gone through the policy advocacy, promulgation of laws in Pakistan, establishing the legal framework, which is very good in Pakistan now, but we need to focus on implementation, which was the core issue. And for that, we have taken the route of judicial jurisprudence law. So these 4 issues were selected, and we will be going ahead with other issues as well. So that was the background from where. So thank you, sir, for instigating the thought process and then implementation by this very able team. And I am apologizing from them that on Eid day I was calling them that this paragraph is not correct. Please read it and relate it to the international obligations. So that was the journey, and in that journey, if you read these studies, you will find that every time you read, you find a new aspect of the law and the cultural norms and the challenges the courts are coming up with. So the apex courts, to me, while listening to the worthy speakers and reading the book, is that they have given 5-6 concrete actionable points for us to go ahead with that. The very first is the protection of individual rights and the role of apex courts, that how they can uphold, and that is the guiding principle for the society, and ranging from individual to policy making, and they have gone to create a social justice in the society. The examples they have quoted, the analysis is given, the challenges and the solutions presented in the case laws is actually a kind of a research-based judgment written by the honorable judges, which is a guiding principle not for the judiciary, but for the lawyers, for the individuals, for the development specialists and the workers, so that they can practice it and increase the social justice within the society. Then the third aspect is the public policy reform and the law reform. There are ample guidance given, and I can count about in each topic, there are more than 10 suggestions which are coming up for the law reform, either a new legislation or an amendment to the law. So it's a guiding principle now coming out for the lawmakers and the legislatures and the advocates for the rights of women and the girls and the children here in Pakistan to take up all these things. Then they have used the international law, which in our courts mostly was ignored a few years back, but repeatedly we have seen the reference to the CEDAW, to international covenants, political rights, economic rights, child rights, convention, and other conventions Pakistan has ratified. Almost even in some of the judgments I have seen the Beijing Platform for Action and the Declaration. So these references are very important to bring Pakistan's positive image at the international level that we are not implementing the domestic law and the Constitution of Pakistan, but we are also cognizant of implementing our international obligations, and our courts are pursuing it and asking the executive and the legislature to do the right way. Then there is a major thing for me which I found after listening to these speakers and reading the book. That is the public confidence in the legal system. There are so many things which are written in these judgments which provides us ample evidence that we can build the confidence in the formal justice system and in the courts of the ordinary people who are shy of reaching it, especially the women of this country. And they have provided some guidelines as well that how easy access can be done by the executive and the other people for the women who are surviving from gender-based violence in the country. So, and the last one to me is, this is a precedent not only, but it will serve as a bench book for the lower judiciary as well as, because to a study UN Women undertook, we led in 2022, we evaluated all the provincial laws which are dealing with the ending violence against women and discrimination against women. And that study of 4 provinces and the federal legislation, we found that 76% gap is in implementation because of the lack of information. Either the judicial precedents are not going to the district judiciary, or the laws are not informed, prosecutors are unaware of that, lawyers who are defending the cases or prosecuting, they are not aware of these things, that these are the developments. So it will be a kind of a knowledge book and a bench book going forward for the people, and to me especially at UN Women and the development partners in the country, it will be a guiding tool to design the new programs for egalitarian society, for a society where we all can live together with equal rights, with freedom, and women have the agency to play their role to build a resilient Pakistan, and that will be, I think, an uphill task this study will be moving forward and taking on. So thank you very much. I am finishing few seconds before.
Thank you so much for observing the proper time. Thank you so much. You can resume your previous words. Now we are starting the real-time panel discussions. And it's time to focus the key highlights of the study, expanding women's rights through judicial jurisprudence, and to have an expert perspective on the study. In this panel, the panelists will discuss key findings, focusing on Superior Court's judgment in Pakistan related to rape, women's inheritance rights, domestic violence, and child marriages. Panelists will offer practical solutions, comparative analysis, and policy recommendations to address procedural gaps and perceptual barriers and the impact of gender-sensitive legal interpretations. They will also focus insights from Nepal's judicial experiences, challenges, and progress in Pakistan, a global perspective on gender justice, and a policy-oriented viewpoint on enhancing legal protection for women and children. Moving forward, I would like to have the honor to invite Justice Sapna Pradhan Mala, Judge Supreme Court of Nepal, she was the driving force behind the passage of legislation to equal rights to property for women, criminalize marital rape and domestic violence, decriminalization of abortion, and maintaining confidentiality in accessing justice. She founded the Forum for Women Law and Development, Nepal, to protect human rights, particularly for women and minorities. She was nominated in 2008 at the First Constituent Assembly of Nepal, where she contributed extensively in negotiating and drafting the new Constitution of Nepal. She was appointed as an independent expert in United Nations Committee Against Torture in 2014. In 2016, she was appointed as Justice in the Supreme Court of Nepal. I request Justice Mala to please come to the stage and have her seat. Justice Dr. Khurshid Iqbal. A distinguished judge at the Peshawar High Court brings a wealth of academic and judicial experiences to our symposium. With a PhD in law, Dr. Iqbal has a profound understanding of both the theoretical and practical aspects of the legal systems. His scholarly work and judicial perspective and practices have significantly contributed to the development of a more inclusive and just legal framework in Pakistan. I request Justice Khurshid to please come to the stage and have his seat. Ms. Aisha Raza Farooq, a former senator and MNA, is the chairperson of the National Commission on the Rights of Child and has been a tireless advocate for the protection and promotion of children's rights in Pakistan. Her work with NCRC has focused on addressing critical issues such as child labor, education, and welfare, ensuring that the rights of children are respected. Ms. Farooq also heads the Special Committee on Anti-Rape Act 2021. Her dedication to social justice and her efforts in policy advocacy have led to significant improvements in the legal and social frameworks, supporting women's rights and children's rights. Her expertise and commitment to creating a safer and more equitable environment for children and women make her the vital contributor to our symposium. We are honored to have Ms. Farooq share her insights and experiences. Justice Sana Akram Minhas, a respected judge at High Court of Sindh. Her judicial career is marked by a strong dedication to addressing issues such as gender-based violence, women's inheritance rights, and child protection laws. Justice Minhas' rulings often reflect a commitment to justice and fairness, ensuring that the legal system is more accessible and responsive to the needs of women. Her insights and experiences are invaluable to our discussion on impact of gender-sensitive legal interpretations. We are delighted to welcome Justice Minhas to our panel. Dr. Zarizana Abdulaziz, a gender expert. She specializes in legal and policy reforms on gender equality. She has drafted legislation, reviewed the revised laws on gender equality, gender-based violence, and family laws in Pakistan, in several countries, as well as trained legislative drafters, academics, and scholars on legislative drafting. She has also conducted judicial training and capacity building, including in Pakistan, as well as provided technical assistance in the setting up of Pakistan's first GBV court. She is also the editor and co-author of the Court Companion on gender-based violence cases in Pakistan. I'm also one of her students. I request Zarizana Abdulaziz to please come to the stage and have her seat. Thank you so much. I am moderating the session. So without wasting much time, my first question is to Justice Khurshid. My first question is to Justice Khurshid. What key findings from the study on expanding women's rights through judicial jurisprudence can be translated into practical solutions to address procedural gaps and perceptual barriers in Pakistan's superior courts? Thank you, sir. You have 6 to 8 and 10 minutes. The presentation is, Hamza, please play the presentation of Dr. Khurshid.
Honorable Chair, Bismillahir Rahmanir Rahim. I'm privileged to be part of this two-day symposium, and again I am privileged to speak on this occasion. Well, I would say, if I'm there. It's not working. Okay, that's not working here, but anyway, so I start from here. I have, yeah, it's working? It's working? Okay. So, in order to look at to create a framework here, I would say that in order to ensure women's right of access to justice in Pakistan, the Women's Committee's 2015 recommendations, Journal Recommendation number 33, could be a starting point. And as you can see on the slides, it says that it says 6 essentials of the right of access to justice, the 6 components: justiciability, availability, accessibility, good quality, provision of remedies for victims, and accountability of justice system. But then the next perspective is the rule of law, and that of course we have been talking about the rule of law in our country, but the point that I want to put across here with rather very stressfully is clubbing the law with culture. As I'll be discussing this in the context of barriers to access to justice, here I would say that where legal and socio-cultural norms clash, the rule of law will be weak. So that's the point that, inshallah, I'll be making further highlighting it. Because and then the rule of law is required to be a norm creation. Unless we have respect for the law and application of the law as a cultural norm, we won't be able perhaps even to start our journey towards the implementation of the rule of law. And how we can come across, we can club the two, and that is the blending of the two perspectives. The law with the culture, sociological perspective of the law, and the anthropological, and that I have given the name legal anthropology approach. The next one is the main barriers to access to justice. And I'm unable to read all the points there on the slide, but what I would stress here is that our harsh adversarial system in the courts perhaps is not delivering that much. It's our system, with utmost respect I would say, is neither Western nor cultural. So we need to go for adopting this system into our own, for embedding this into our culture. And then the very much akin and aligned with that is the understanding, the proper understanding of the justice system, the legal and justice system. With utmost respect, again, I would say that a vast majority of our people do not know about are unable to read the law. And it is very much important that the laws should be clear, understandable to the people, but that is not there. We have the mode of communication. We know the general masses do not have the opportunity, that they are unable to read the law. So if they are unable to read the law, if they are unable to understand the law in their own language, in their own cultural perspective, it would not be possible for them to go for the protection of the women's rights and even to have an opportunity of access to justice. Then if we go a bit deeper into this perspective, we have the gender biases inside the court, right from the presiding officers all the way down to the very paralegal staff there. So similarly, we have the social stigma perception, and it is very much, we all know, it is very much clear to us that even in our society, when a woman takes an opportunity, when a woman rather ventures to go to a court for enforcement of her right, even that is attached, a stigma is attached with that, that look, she has gone there and perhaps to put it on a lighter mode, she has become uncontrollable. So that's, even the very access of justice itself is having a kind of stigma attached to it. And of course, the lack of confidence in the justice system, the lack of awareness about rights, and then one thing more, the revengeful victimization of women. When they seek justice in the court, they face what I can say revengeful victimization, the secondary, victimization of the women. Okay, what are then the perceptual barriers? I have had a little bit of that, and here I would explain it more. So we have explicit and implicit bias in and around the court, and for that we need to adhere to, and for that we need that all justice sector personnel, all those who are working in the justice system, they must adhere to the international standard and the dignity of women. Then we must explore and shun the biases. Similarly, we should avoid generalizations and assumptions about the victims who approach us for justice. And we should avoid treatment on the basis of class, caste, race, and even profession. So I would then jump to the next one, and that is the procedural gaps. We need to align our existing judicial system to a community-based system, where we have the community-based judicial system, and we would be able to come across those challenges. The next one is the safety net deficiencies. So disregarding clearing of courtrooms in the sensitive matters. Where the sensitive matters are being heard, we must be very much considerate about the environment inside the court. Then the generalization, disregarding the generalization. We should disregard generalizations, and judges should intervene where judges feel that there are stereotyping and there are perceptual barriers, and when that is being displayed in the court by lawyers, by the parties, the judges have to intervene into that. Similarly, we need to have the structural changes as well, such as the facilities in the court and the use of the simple language. Most of our litigants do not know about the documents, the petitions that are written there and that are being produced. I'll come to the next to the policy recommendations. So The policy recommendations that I have with me is the community-based family dispute I already talked about. So we can, in that perspective, we can go and move forward by having cultural legal advisors in that community-based system. And there should be online portals for confidential reporting to ensure privacy and protection. And we can create virtual court rooms as well, where women who are unable for one reason or the other to go to the court, so they should be facilitated. That's it. Thank you very much.
Thank you so much, sir. My next question is to Justice Sapna Pradhan-Mala. How can gender-sensitive legal interpretations and policy recommendations from this study be used to enhance legal protections for women and children in Pakistan? And what lessons can we learn from Nepal's judicial experiences and global perspective on gender justice?
Thank you, and thank you for having...
You can avail 10 minutes, thank you.
Thank you for having us here. Yes, judicial jurisprudence matters because it can bring reason behind the law, and it helps to bridge the gap of law, policy, procedures, and it can also sometimes correct the law, and it can make the law contemporary. More importantly, it can empower, it is an opportunity that empowers among us to give the life to the law. And in fact, what I would say, the judicial jurisprudence can help laws to put in place, bringing due diligence. So this is a big opportunity we all judges have. So congratulations for wonderful study which you have conducted. It has really highlighted what you have achieved. But not only highlighted what you have achieved, but what way forward you have given to realize the paper, the judgment in the life of the people, life of women. So it's very important. But in this process, what also I feel important of this study is, because it is not only a document that can give us what we have achieved, but I think sometimes it can also give us feedback on what went wrong, where we went wrong, how we should have gone with our own judgment. I think sometimes those kind of critical feedback is also important, because once judgment is delivered, it's a public property and people can criticize. People can give feedback and comment on us. And sometimes, because what we have also done in Nepal, we also did some geometrical study. Because as Khusid has pointed out, we have been talking about unconscious biasness, but there is a conscious biasness, there is a prejudiceness, there is a stereotyping which is prevalent, not from the time people access to the court, in the process, even after judgment is delivered. It's not only prevalent in the society. So I think identifying those things also matters to be us more conscious, so that the consciousness is reflected in our judgments. And I was also quite inspired yesterday by Women and Law Initiative. In fact, they have recognized what women have been doing, what women can do, especially in a South Asian society, where the assumption, the notion is that women cannot do. And women's competency is every day questioned. In those social contexts, your initiative to recognize and to reflect what we have been, women have been able to, women have been doing, and not only nationally, you have also example of women being even in International Criminal Court, is quite a progressive and important documentation. I think we all have to also things to take away from Pakistan. Third thing, I want to connect again with the study. The study matters because sometimes study can bring evidences. And what helped, in fact, even in Nepal on gender jurisprudence, the mapping of law and mapping of critical analysis of judgment. Because when it comes to Nepali context, Nepali law, women had no right. Law was discriminatory, and even interpretation was influenced by the patriarchal mindset. So the documentation, the study in Nepal tried to do critical analysis of the effect of the law, effect of the judgment. Not only effect of law, but we also tried to see effect of some of the judgments. So based on those critical analysis, we use that document for advocacy. For example, women's independent existence. Women as was not recognized. Women were always seen as a dependent notion of citizen. So we challenged the law based on those documents. We challenged even some of the interpretation. As a result, so many changes are taking place, and there is a complete transformation on judgment. But then what comes as a major obstacle in our society? Because when you challenge the law, when you challenge some judgments, everyone stands against you. The religion, culture, custom, tradition, which are the powerful agency of the state. And therefore, evidence-based study, evidence-based case study is important. And what we did in this process is, I think, Justice Kusid, you have pointed out certain things. Ratification of CEDA and using CEDA framework, the non-discrimination framework, the equality framework, state obligation framework was quite instrumental. Not only identifying what discrimination, but going into deeper on indirect discrimination, not only in recognition in law, but also in enjoyment, in exercise, looking into the effect of the law. And while challenging those law and judicial interpretation, we didn't only challenge the patriarchy, but we also recognize that patriarchy is also within women. It's not men versus women, but within us there is a problem. And then we are not against the religion, we are not against the culture, but we are only against the discriminatory against the discriminatory culture. We are for fairness, for equality, for justice. So what you have identified in your study in this judicial interpretation on balancing cultural values and legal norms is quite important. And then I want to highlight one case of Nepal, especially the changing the rape laws, especially the marital rape law. Nepal had a law that said rape means raping others' wife. So your wife was excluded, and then the law was challenged, and the court says consent is the basis of marriage, and in the absence of consent, when marriage cannot be solemnized, therefore sexual relationship, even after solemnization of marriage, cannot be recognized. So in that case also recognized marriage is not a license for sex. Marriage does not mean you have a duty to consent for everything. So even within the marriage, it has to be a consensual marriage. But having this judgment, law was changed, but law was made bailable with 6 months imprisonment, and immediately 2 women filed the case, and those 2 women went to the court, and there the court says, no, you cannot discriminate on the basis of your relationship. And finally, I would like to say, re-evaluating evidence which you have in your study, and sometimes re-evaluating evidence is important, and I want to share one of the judgment where there was acquittal of the accused because there was inconsistent statement of victim. And in this case, the court recognized rape trauma syndrome. At the same time, the court said, in case of rape, why you are looking at you are denying, why you are not able to establish the rape because of there is a inconsistent statement on location. In this case, court says, when it comes to rape, woman's body itself is a location of crime. I'll stop here. Thank you.
My next question is to Ms. Aisha Raza. As chairperson of the Special Committee for Anti-Rape Act, what special measures have been taken under this law to check rape and sexual offences? What are some challenges and way forward? I have another question. And in your capacity as chairperson NCRC, what legislative and policy reforms are you working on to check child marriages? Thank you.
Okay, thank you. I'll try to do justice in this 6 to 10 minutes. Thank you. So I think I'd just like to talk about the Anti-Rape Act 2021. I think it's a big milestone in pro-women legislation that have been done in the country, with a conviction rate of rape and sexual offense crimes in the country as low as, according to some estimates, at 3.6%. The idea was to give speedy and expeditious justice to rape and sexual offense victims here. So the definition of rape was expanded to include not just the act of rape, but marital rape, unnatural offenses, and so forth. It was made gender neutral. It has provided special structures to give confidence to our women and girls to come forward and report rape. So the special committee that I head has established, has had special courts and special prosecutors designated across the country. There are anti-rape crisis cells set up in all district headquarter hospitals and model anti-rape crisis cells in ICT as well as our provincial capitals. The idea is to give all services of registering an FIR, medico-legal services, psychosocial support under one roof to our rape victims here. Then there are special sexual investigation units set up in police stations across the country, which of course their true implementation, the committee is continuously monitoring, we're collecting data, and this is just a step in the right direction, and much more needs to be done. I must here laud the landmark judgments that we see compiled together, one by Honorable Justice Aisha Malik, where when you were a part of the Lahore High Court, where the two-finger virginity test was called a violation of a victim's fundamental right. That is another thing the Act also upholds. Then we saw Honorable Justice Mansoor Ali Shah talk about the DNA test as a gold standard here when it comes to analysis or collecting evidence in rape and sexual offenses crimes here. And these are things the Act also talks about. I don't think it is truly implemented in letter and spirit across the country, but that is something that the Special Committee is monitoring and overseeing and collecting data on. This Act also, as Honorable Justice Khurshid has mentioned here, talks about maintaining the confidentiality of our victims, of allowing evidence collection, or getting the testimony through confidentially through our I'm forgetting the word that is used here, electronically or remotely through the new system that has been instituted in courts here, so that the dignity of a victim is ensured here, not looking at a victim's past sexual history and so forth. So it is one of its kind, a landmark legislation. But as with all legislations, they remain words on paper till they're not implemented and till awareness is not created. And I think that is where the country lacks here. So we're trying to ensure that this, people are made aware, girls and women, they're given the confidence to come out and make use of this act by reporting the crime. And that is where the continuous victim blaming and victim shaming that we see from people in positions of power, be it leaders, political leaders, religious leaders, etc. That certainly needs to change. So it requires a transformational behavior change in our society, where not just as parents, as brothers, as colleagues, but as leaders in the country, we ensure that we allow women to come out, report crime. Starts from the police thana. I've heard, we've gone to police stations where they've admitted themselves that, you know, we'd rather say, why don't you settle for an out-of-court settlement here? And, you know, it will lead to a lot of shaming later on, and your family is going to be in the negative light here, etc., etc. So those are things that we need to change. And certainly in his opening remarks, Justice Mansoor Ali Shah has set the tone, and it's very reassuring to see he's talking about how there should be greater representation of women in the judiciary. There is plethora of data which says that when the first responder in the police station is a woman, a female, the reporting is much better, because a young girl or a woman victim is more open to report her crime with greater trust here. Similarly, there'd be greater empathy we'll be able to see, and more victim-centric approach if we have more women in judiciary, both lower and in our superior judiciary over here. And we hope that this conference is going to lead and have some outcome of where we can work to increase that representation faster. And then training and capacity building, I think that is critical over here. We have seen that all actors in the criminal justice system lack training here. They're not too aware of the act itself. And we are, through the special committee, conducting those training sessions. But I think we need to step up our initiatives and take it all over the country, and not just in metropolitan cities or capital cities of the country. My apologies, I'm talking too fast. I have a lot to cover here. Your next question is regarding the other hat I wear, which is as chairperson of the National Commission on the Rights of Child. We see how Pakistan globally is the 6th nation with the highest number of child brides in the world. And we know how early marriages or child marriages rob children of their childhood, disrupts education, makes them more susceptible to violence, sexual abuse, and so forth. And how young brides, when they become young mothers, leads to all kinds of issues, health issues, maternal health, and health issues with the young born also. So the Commission took upon itself to lead, number one, legislative and policy reform, and we conducted advocacy sessions with all provincial chief ministers, and went to chief secretary offices also, other than Sindh, where you have the Child Marriage Restraint Act, where the minimum age of marriage for a girl is the same as for a boy, and set at 18 years. I'm happy to report that it may have come as a result of a judgment of the Lahore High Court, but the Punjab Cabinet has also approved a bill increasing the marriageable age of girls to 18 years as for boys. And in Balochistan also, through our advocacy efforts, the Balochistan Cabinet has also approved a similar bill to be placed before the Assembly. Now that's one part of it. We are also propagating that wherever we see any violation of this act, whether it's the Nikah Khawan or the Nikah Registrar, Secretaries of Union Councils, or parents and abettors, there must be strict punishment, and not just the severity of punishment, the consistency of punishment is important here to deter early child marriages. Otherwise, you'll continue to see young girls as brides in your country, and you'll see high dropout rates in education. And Pakistan has one of the highest out of schools in the children. And one reason, there are many others, is how young girls are forced out of school and then wedded early. The third thing we're propagating is for stricter punishments here, and also looking at how, and there is one judgment I saw of Justice Babar Sattar here that declared a marriage under 18 as null and void. So what happens, and this is for the judiciary and jurisprudence to interpret the law, especially the Muslim Family Law Ordinance, what happens if and under 18 is wedded off? Can you declare that marriage illegal, void ab initio? Is it against the Sharia law? There are judgments supporting it that it can be declared, but we would like our superior judiciary to interpret this law in light of changing and evolving social dynamics to protect the right of our young girls and children as well as their health. Thank you.
Thank you so much, Ms. Shaista. The courts at all tier are gender sensitive now, and we are glad that government is also mindful of the gender rights and the ground realities. My next question is to Ms. Justice Sana from Sindh High Court. What is the meaning of gender sensitive legal interpretations? And can you give few examples of how GSLI can promote fairness and equality in legal context?
Well, gender-sensitive legal interpretation basically, in simple word, means that understanding how laws and legal decisions can affect different genders differently. For instance, a man or a woman's experience of the same situation can be different, and that is then applied to the legal decisions, but as a result of which the outcome may be different. It addresses or it approaches with a different perspective. It addresses unintentional biases. For instance, laws or policies may favor one gender over another. For instance, we may have hiring policies. A company may favor a policy where it promotes or it values uninterrupted work experience. And we will see that this would favor men because women are more likely to take time off for maternity leave or for child care. And then again, coming to how it recognizes the differences, like I said, the same experience of a man or of a woman of a situation can be different. For instance, workplace harassment. I mean, a leery smile or a lingering look, a man may not notice it, but for a woman, that can have some repercussion. She may feel uncomfortable. Then again, both a man or a woman, they can be recipients of an unwanted remark about their appearance from a co-worker. A man may feel annoyed by it, or he may feel uncomfortable, but a woman may feel both as well as feel threatened by it. So a gender-sensitive approach would then give a better protection to women by giving a much more stricter view of the same situation. Then we also have domestic violence cases. We usually have this traditional view and concept of physical violence, and statistics show women are more prone to harm because of the power imbalance and the cycle of violence. So while a gender-sensitive perspective or lens can broaden the definition of domestic violence, and in addition to physical violence, it can factor in or take into consideration emotional abuse as well as psychological abuse. I mean, you hear this common refrain in homes that, what kind of a woman are you? You have not even made this well. You've destroyed my day. You've started this again. You yourself are not educated. How will you educate the children? So, that kind of a thing, that constant tongue lashing, that too is a form of an abuse. Then we can also have this financial, economic abuse, where the finances of a woman are controlled by men so that they remain dependent. And it reminds me of one incident. It's a depressing one, but this happened in Karachi. An acquaintance of mine, she runs schools for children from low-income groups. And one of the girl child, or she was around 7, 8 years old, she came to the administrator's room for a few days. She would go back. She would come again, and then go back, but she wouldn't enter the room. One day she finally mustered the courage, and she went in there, and she told the administrator what was happening, and she stated that her father had been physically abusing her. And she was only 6, 7 years old. And they asked her for how long it has been going on. And she said, it's been going on for at least 3, 4 years. They asked her, why have you come forward now? And her answer was, because the father has now started abusing the younger sister, who was only 3 or 4 years old. So they called the mother. And the mother's immediate reaction was, of course, that of denial, that nothing like this is happening over here. And then, she asked her daughter, for how long has this been going on? And she said, 3, 4 years. And the mother says to her, why did you not tell me this before? You must be enjoying it. I mean, I'm saying this in English, it masks the dreadfulness of her remark, but if I say it in Urdu, what she exactly said to her daughter was, "Tune pehle kyun nahi bataya? Tujhe maza jo aa raha hoga." You know, these kind of mindsets that we have over here. So what they then did later on, of course, the administrators and the teachers, they really gave the mother a firing for even saying this to her own daughter. And then the mother broke down. She confessed, she knew about it, that it has been going on. And then she says again, I'm saying this in Urdu, and she said कि मेरी 5 बेटियां हैं, मैं उनको लेके कहाँ जाऊँगी? मेरे पास रहने की कोई जगह नहीं है. In translation, I have 5 daughters. Where will I go with them? So this is where financial abuse comes in. Then the schools, they help the mother find a job in the school, and that helped her leave this kind of a hell of a life that she had been leading. But which brings me on to another topic, which I would be digressing, I won't elaborate. But then you read this in the newspapers, that jobs of women are increasing or are a cause in the divorce rate, jacking it up. But for this kind of a situation, it is not the jobs that are causing a divorce. This is kind of a release from hell for them. And then another example we can have is that of workplace discrimination. And for instance, women are passed over for promotions. There was this famous case, American case of PricewaterhouseCoopers and Ann Hopkins. She was a partner in the firm, and she wasn't promoted. She was passed over the first year. They said they'll consider it her next year. And then the second time, again, she was passed over, and she resigned. She sued them, and the case ultimately went to the Supreme Court. She won before the lower tiers. And one of the remarks that was made by the male partners when they ignored her or overlooked her promotion was that she was not feminine enough. She was too macho, the way she would dress up. So, there is no perfect balance for a woman where she can, what she can really do. And just to conclude, on a lighter side with another anecdote, it was my early starting years as a lawyer. I started off in the firm of Mr. Naimur Rahman. He was a deputy attorney general at that time. And it was summer, June, July, and he was flying out the next day for his summer vacations. So I remember there was somebody from the tax department, a few people, they came over, and in the evening, the day before he was leaving, and they asked him, they brought a notice, they had received a notice from the High Court, and they said, is case may, they haven't passed any stay order as yet, and we would like you to appear tomorrow and prevent the party from getting any stay because otherwise the amount of money would get stuck up. So Naim Sahib replied that I won't be here, I'm leaving, but I will send Mushir to appear. And the immediate reaction, I'll say this in Urdu and I'll translate it later in English, of the men sitting over there, and they immediately said, nahi ji, ek khatoon hamare liye kya kar legi? Meaning thereby, no, don't send her. What will a woman do for us? And Naim Sahib replies that Mushir is not a woman, he's a man. So they breathed a sigh of relief. And for those who are present over here who may not have may not know, the lady in question, he then went on to become the Chief Justice of the Sindh High Court and also a judge of the Supreme Court. I'm talking about Mr. Justice Mushir Alam. So, the moral of the anecdote is that for those of us women who think that being a woman is tough enough, having a feminine name can be just as hazardous. That's all.
Thank you so much. Women can do wonders if they are given an opportunity, and you all are doing their wonders. My next question is to Ms. Rizana Abdulaziz. Your work is focused on human rights and its interactions with gender, the constitution, law, and culture. How does violence against women fit into this framework? And should I ask all questions in one go, or should I ask one by one? So, mic is yours.
Thank you, Judge Shazia, Justice Mansour, Justice Aisha, Mr. Hayat Ali, and from UN Women, Mr. Lansana and Ms. Shamila Rasul, distinguished guests, justices. Thank you to FJA and to UN Women for inviting me, and congratulations to Dr. Samira Fatima, and her team for an excellent report. So answering your question, Madam Moderator, is we should look at violence against women from a rights framework. When we talk about a rights framework in human rights, we talk about the Universal Declaration of Human Rights, CEDAW, but we have to remember the rights, the human rights entrenched in international human rights law is actually mirrored and reflected in the Constitution. So we're also talking about the Constitution. When talking about equality, it exists both in international human rights and under the Constitution. I just want to touch on equality, because the one thing that we can learn from international human rights on the question of equality, and I'm talking about this because Justice Mansour spoke about equality and equity, is that equality has been defined and deconstructed under international human rights law, under CEDAW. I had a picture, I'm not sure whether you can put it up.
I sent you the picture.
Now, equality under human rights, you have the formal equality, like giving the textbook to everyone, that's formal equality. Now, we have substantive equality, which is the gold standard of what equality is. Substantive equality talks about three kinds of equality. It talks about equality of access, equality of opportunity, and equality of outcome. And all three has to be there for equality to happen. Now, equality of access means that we have to provide, if you can put the picture, if not, I'll describe the picture.
Can you arrange that picture, please, which I just WhatsApp you?
Okay, so imagine this illustration where there is a wall and three people are, okay, here, all right?
On the main screen. Hamza, on the main show.
Yeah, okay. On the left is what we're talking about, formal equality. Each person is given a box or a textbook. Formal equality, we're done, finished. But no, that does not bring about equality because we are not playing on a level playing field. Substantive equality is the man obviously does not need a box. He can watch, he can see. Don't give him a box. The woman needs one box to be able to see, so give her a box. The child needs two boxes. Now, the result of this is you have equality in outcome. You gave them the opportunity, you gave them the access, and the equality in outcome is what we are looking for. Yeah? So, and in order to achieve that, human rights talks about special measures, fundamental liberties under the Constitution talks about special protection. Yeah? Now, a lot of constitutions have this. It mirrors international human rights and equality. It contains the rights and freedoms. I don't think I need to go through the constitutional provisions, but what I need to emphasize is constitutional protection not only happens in the high courts and the Supreme Court. It happens every day in the district court and in the session court. And if I may quote Fakir Hussain, which I'm sure you all know, he talks about constitutional rights are not upheld only by superior courts. The district and session courts play a critical role in enforcing constitutional safeguards. For example, protection of law. So every day, this is what you're doing. When you talk about violence against women, you are talking about constitutional rights. Now, the other issue we talk about when we talk about human rights is that it's against culture. Yeah? Human rights recognize that cultural diversity is an imperative, but what it doesn't allow anyone to do is use culture, invoke culture to infringe upon the rights of someone else. Yeah?
So, can I ask another question? What do you think are perceptual barriers to rape victims, survivors accessing justice, and what can judges do about these perceptual barriers?
Yeah. Yeah, when I first came here, I've heard so many criticism. Why are we talking about violence against women? Yeah? In fact, some go on to say it doesn't happen in Pakistan. Rape doesn't happen in Pakistan, yeah, because we're all good Muslims, yeah. Now, rape happens everywhere. Yeah, violence against women happens everywhere. Yeah. So the social perception, of course, is difficult to prove. And because it's difficult to prove, the consequences, women lie. Because you can't prove it. So it's false, it's fraudulent, it's even malicious. Yeah? And that, to a large extent, has been corrected by the judgments that we have seen, as well as by the establishment of the GBV court, which put in all the special protections. The other issue that fuels this is the issue of women resiling. Yeah? This is a specific issue that is very critical. Yeah? And why do women resile? And when they resile, there is a funny little cookie cutter, yeah, if I may call it, formula that is used, that there was a misunderstanding. Yeah? The misunderstanding has been resolved, it has been satisfied, and it has been taken before a reputable of the locality. Yeah? And when it happens again and again, surely something is wrong. Yeah? This is where judges need to scrutinize this. Now, the issue with resiling is because the issue that people think they can use qisas, right? They can pay diyat, and if you can do it for murder, why not for rape? Yeah. Well, not only is it prohibited, it's not allowed. There's no provision for diyat anywhere, yeah, under Islamic jurisprudence for sexual assault and rape. Right? Now, one of the issues is, of course, financial gains from compromises. What can we do about that? The courts, the law has already provided for reparation. And this is something that needs to be accessed more, reparation. Now, reparation is provided under both the Pakistan Penal Code as well as the Criminal Procedure Code. Yeah? You have under the PPC, Section 53, Daman, which is part of punishment, actually. Yeah? You can order it for compensation for expenses, loss, disability, for anguish. You also have under the Criminal Procedure Code, in the event of death, hurt, injury, mental anguish, psychological damage, property damage, the court can, for reasons recorded in writing, order payment of compensation. Yeah? To some extent, if you provide reparation, I think it will resolve this perception that women lie because the family has taken money or compromises. Reparation is the next step, I think, which we need to use, because punishing the perpetrator alone is not enough. We have to push forward the idea of how can the woman, how can the victim survivor rebuild her life? Yeah? And how can the court, how can you provide this, and in providing this, manage to change the social perception that women lie, yeah? Because it will reduce, hopefully, resilience.
Thank you so much, Ms. Rizana. We have session takeaways, and for that, I invite Mr. Fakhar Zaman, who is a distinguished career judge in Pakistan's district judiciary, renowned for his expertise in judicial education, legal policy analysis, and governance. With over 30 years of experience blending civil service and judiciary roles, he holds academic accolades, including a gold medal in law and a master's degree from University of Melbourne. His career highlights include leading institutional reforms, serving as additional secretary in Khyber Pakhtunkhwa, and consulting for UNDP. Currently, he serves as secretary, National Education Coordination Committee, overseeing the implementation of alternative dispute resolution mechanism and legal aid initiatives in Pakistan. Over to you, Mr. Fakhar. Thank you.
Thank you very much, Razia, for the generous introduction. Ladies and gentlemen, very good day. I would not bother you much. I have just very crisp and distilled wisdom, which we can take takeaways. And from this panel, I have taken these words. The first and the foremost thing is, which was almost new for me as well, was the legal anthropology approach. That whenever there is a clash between legal and social norms, the courts must adopt legal anthropology approach by blending both legal and cultural norms. The second is judicial trainings. As a distilled wisdom from this panel, There is a need for continuous training of judges on gender-sensitive legal interpretation. Next is policy reforms. We need specific policy reforms to address procedural gaps in handling cases of rape and domestic violence. And support systems. There is importance of establishing strong support systems for women in contact with law, including legal aid and counseling services. And the last one, public awareness. The implementation of public awareness campaigns to change societal perceptions about women's rights. Thank you very much.
With a bundle of thanks, I request the panelists to have their seats in the hall, and we have a lunch break. Thank you so much for joining us for this session.
Ladies and gentlemen, I want to have your attention, please. So we have to start the next session at 12:15, and we already have 12:15. It's 12:17. 2:17. Sir Amir, Sir Jahanzeb, would you please help me? लोगों को बिठाएंगे आप, खुद बैठेंगे तो फिर वो बैठेंगे. Ma'am Afshan, can you please go back to the lunch venue and request everybody on my behalf? उसको रोक सकते हैं वहाँ पे. हमजा, वीडियो तीनों जो है ना कोट्स, उस पे रोक दो 1-1 मिनट के लिए. ये कोट्स है ना, वीडियो 1-1 मिनट के लिए मतलब प्रेस कर दो उसको, स्टार्टिंग फ्रॉम. और तुमने नया वीडियो नहीं चलाया मेरे पास, वो है वीडियो है ना, शॉर्ट वीडियो थी 30 सेकंड्स की. आप इस तरह करें, जब कोट्स आ रही हैं तो वहाँ पे रोक दें ना, इससे पहले बैक जाएं. ये पहले ये रोक दें, फिर इसकी पिछली, फिर इसकी पिछली. Assalamu alaikum. Welcome back to the next session. Now I have the honor to invite Justice Aisha A. Malik for her plenary session on the gravity of issues and impact of lack of representation within the judiciary and overall. I could not write my own writing, read my own writing. So I am introducing Justice Aisha A. Malik. After serving at Lahore High Court for 10 years, Justice Aisha A. Malik made history in 2022 as the first woman to be appointed as a judge of the Supreme Court of Pakistan. Her appointment marked a significant milestone as Pakistan became the last country in South Asia to include a woman on its highest court. Justice Aisha Malik recognizes the importance of integrating the gender perspective in the judicial arena. She has actively highlighted this in the trainings she had conducted for judges from abroad, around the world, as well as in the conferences for women judges in Punjab and Pakistan. Through such initiatives, she strives to bring the issues to the forefront and promote a more inclusive judicial system. Justice Aisha's judgments in matters pertaining to women have been lauded nationally and internationally and have brought the impact of gender perspective to light. These include, I am reading some of the quotes from the judgments, declaring the virginity test as violation of human dignity. She said that in Sadaf Aziz versus Federation of Pakistan. Then expanding the definition of sexual harassment in the workplace harassment law in Nadia Naz. And then there is another landmark judgment, which is Raja Tanveer Safdar, Mrs. Tahmina Yasmin. In recognition of her work, Justice Malik was included in the BBC 100 Women 2022 list, which recognizes 100 inspiring and influential women from around the world. Additionally, Forbes honored her as one of the women who made global history in 2022. Today, we certainly are proud of her. She is a pride of Pakistan. Today, we have the honor to have her here with us. So let's welcome Justice Aisha Malik with another round of applause on the stage. Please come to the stage, Justice.
Good afternoon and assalamu alaikum. So post-lunch, everybody feels a bit dull and sleepy. But what I'm going to share with you and speak to you is neither dull, nor should we sleep on it. I think we've done enough sleeping, so it's time to wake up and think about how to change things. We've had a very interesting morning, very informative discussion on the jurisprudence that has evolved over the years and on the way that that jurisprudence has helped shape a new narrative. But the discussion that follows from now onwards, that's what's going to really make a difference, because that's the discussion that's going to tell us how do we change things, where are the problems, and how to make a difference. Let me first start by thanking the organizers, UN Women and the FJA, for organizing this wonderful event for a topic that is very close to my heart, which is being discussed today at a regional level. And I say this not just simply as a woman judge sitting here, but I say this as the voice of the many women in the justice sector, the many women who are not able to say some of the things that I wish to share with you. The next 2 days are going to be very important as you discuss various aspects in your panels and you debate on what is meaningful inclusion and how to achieve meaningful inclusion. It's important to give some perspective, the gender perspective, on why meaningful inclusion is important. For me personally, this discussion is critical because it addresses three very important topics, three very important issues, which I, as a judge over 13 years, have been trying to voice out how relevant and important they are. Number one is the lack of women's representation in the judiciary. Number two is the lack of a gender perspective in the judiciary. And number three is to make our system more gender responsive, not just for the judges and the lawyers, but more specifically for the female litigants. It's a very tough environment. It's a very man environment. And it's very difficult to just say access to justice, come to the courts. It's very, very difficult for these women who come from very difficult home lives, in very difficult circumstances, to come to our system. So we need to know how to address these problems. And you heard Justice Shah in the morning when he shared some very dismal data to tell us what the problems are and how those problems are translating into bringing less women in the judiciary. They're kind of running away, or they're not interested in this profession, and there has to be a reason. We have to understand that reason before we go and take action and try and include more women in this. It's also important to look at the study. I think the study is very good because it brings out the good jurisprudence. It brings out the manner in which a change in the narrative can help change the way people think. But now I will begin by sort of doing the part that is not so exciting, but bringing out more dismal facts and more dismal issues that need to be spoken about. So why is it important when we look at women's representation in the judiciary? Why is it important? And Justice Shah told us and gave us the demographics. 49% of the population are women. So when you don't have women sitting on the bench, when you don't have enough women lawyers, prosecutors, women in the Advocate General's office, Attorney General's office, women on the decision-making table, you actually are not listening to the voices of those 49% of the women. You're not taking into account their stories. And when we as judges hear cases and write judgments, we're actually telling a story. We're actually telling a story about the litigant who's come to the court. So it does matter whose story you're telling. And if you're going to write about the woman's story, not from her perspective, but from your own perspective or from the given narrative, then you're doing her a big disservice, because that narrative is drowning out her voice and it's drowning down her rights. We're ignoring what really matters for her, such as her right to dignity, her right to privacy, her right to equality, her right to fair treatment. Now, inclusion goes to the root of these fundamental rights: the right to access to justice, the right to be treated equally, and the right of participation and opportunity with dignity. And when I say with dignity, I underline with dignity, because I don't want to beg and plead for that chance. I don't want to beg and plead for opportunity. I want it to present itself to me. I don't want to have to say, I'm here, please listen to me. I want to be heard without having to say that. So where is the problem? And let me tell you that I have spoken to many women judges, many women lawyers, prosecutors over the past 1 month, just to understand where the problems are and what these women have to say. And I think all of them unanimously believe that the problems are visibility, they're just not seen even though they're there. Acknowledgement of their work, their participation, and their merit. Inclusion, they're never considered, they say, for anything. And participation, their involvement is limited. It's restricted and it's limited. So these women say that at least give us a chance, at least hear us, at least consider us, and most importantly, please talk to us. When you're going to think about how to make a difference, talk to the women. So I think this is very important to understand that for meaningful inclusion, you first have to know what is meaningful to these women, not what is meaningful to the system, or not what is meaningful to what I think is meaningful, but what is meaningful to these women. And that's what will make the inclusion meaningful. This leads us to something that I've spoken about very often, and that is the gender perspective. The gender perspective is critical to any judicial system. Unless you don't have a gender perspective, you're not going to be able to give the right to that woman in its whole form. You won't really recognize the issues that she has spoken about, and you won't be giving her the justice that she has come to seek. So it's important to understand what this gender perspective is. And the way I sum it up is that the system basically is one that's made by men, the laws are made by men, the policies are made by men, and it's all given to us. It was given to me when I became a judge, and I was told for my friends in English, my English friends rather, in Urdu I'll just say it, कि madam ऐसे ही होता है यहाँ पे. So I've learned this, कि ऐसे ही होता है, meaning this is the way it's done. This is the way we do it. And I'm here to say, no, ऐसा नहीं होता. I can't do it that way. So please try and understand that certain things I cannot do. And you have to change the way you do things so that I can be included in the fraternity, so that I can be included in the justice sector just as much as anyone else. So let's look at this from the jurisprudential point of view. We heard about the great judgments, and yes, we've come a long way in recognizing the rights of women. We've come a long way in recognizing that these rights are connected to dignity and life and quality and privacy. It is important. But more important than that is that we have to understand that there is a mindset. And that mindset is very, very strong and very prevalent in our society. And it comes out in the courtroom. It comes out even in just the way our court conducts business. It comes out in the way we speak. It comes out in the language that we use. So when we speak about things like gender-based violence or rape cases, when we speak about harassment issues, when we speak about offenses against children, it's very important to keep in mind the victim's perspective, because it's the victim's story, and the judgment is for the victim, not for the accused. We are trying to understand what the victim felt. And so in that, I think it's important to understand and underline that the gender perspective is important. Let's not rely on customs and traditions and presumptions and assumptions and what I think I understand of how things will be. So it's important to understand that it is the victim's story. So when a woman walks into a courtroom and says that this is a complaint of marital rape, then the judge is not supposed to sit and think about it that, nee, this is a private matter, this is a family matter, please don't talk about this in court. If she has had the courage to come to the court, they're not looking for what her uncle or father or mother would say to her, but she wants to know what the judge is going to say to her as per the law. And the judge has to say what the law says, not what he or she thinks, what they think is right, what they think is wrong. When she comes to seek a divorce, we don't say, nay, for the sake of your children, please go back home. No, that's not how it works. If she's managed to come, then give her what she wants if she's entitled to it. But don't assume that for the benefit of the family or to preserve the family, it is your place to tell her that she needs to go back home. When it comes to rape cases, it's scary, though, the language that we use and the way we think. And we still continue, despite the stellar judgments, despite the fact that we have judges who recognize scientific evidence, recognize that merely statement of the victim is enough. We have our judgments continue, particularly in the district courts and unfortunately in the high courts as well, to use words like habituated. She's habituated, or that she's divorced, or that she's a widow, so we don't really know whether this was rape or not. And also to blur the difference between rape and consent. I really liked what Sapna said today, that the offense of rape takes place on the body of the woman. That's what has to be kept in mind. That is so fundamental. And even though we have judgments that say previous character doesn't matter, we now look at previous character through behavior. So we start analyzing her behavior, and we start assuming that we understand better how women under trauma react. I mean, I'm not an expert, I'm not a psychologist. I don't know how women under trauma react. And so I can't say that this is not how a woman would behave or would react. We've said in our judgments that resistance marks are not necessary. You don't have to show resistance. But yet we assume in the court that marks of resistance are necessary. And let me ask all of you, do all of you know what marks of resistance look like? Are you experts on that? Do you understand that this is a mark of resistance and this is not a mark of resistance? So why are we relying on things we don't understand? And if we think they are relevant, then let's rely on what the experts say. Let's start calling in the experts and ask them what they think. But that's not the point. The point is that she says it's rape, and we have to look at what the role of the court is, the gender perspective. Now, my time is short and my list is very long. I could go on forever to explain what the gender perspective can do and can't do. But I think what is important is, and what I want to say is, that the gender perspective is what makes the system more inclusive. And the more we understand and respect the gender perspective, the more we try to include the gender perspective, the more we will make our system inclusive. And for that, we have to be willing to understand that there is a different way of thinking. And we have to respect that different way of thinking. And we have to respect the fact that while I and my colleagues might come to the same conclusion in the law, my reasons might be very different. My understanding may be very different because it's based on a different premise, because it's based on my life experiences. It's based on my perspective, which is the gender perspective, which is what is important. And this, unfortunately, can't be done through training alone. So here I have a question, particularly, or I leave a thought, particularly for Justice Shah, that it's not just about training. And I think judges now and court systems should now look at what is their role in creating awareness. What is their role in putting things out to society and bringing judges with society, connecting the two to make society understand what rights are, where they stand, and what it means. I mean, is it necessary that we have an intermediary in the middle who's going to do the translation for us? Or is it time now that we think of how we can, as women judges, as communities, start reaching out to our people, to the people whose rights we're protecting, and see what we can tell them and how we can tell them. Different countries have done it in different ways, and there's a lot going on. The Women Judges Association does a lot that way, and there are many other associations, and we can talk about that. But I think this is important to think about, that it's not just capacity building and training. You have to change the way people think. And how will you change the way people think? So while we have these great judgments, enforcement is poor. Enforcement is poor. You don't see people, you still see women coming for inheritance. You still see women struggling over custody rights. Rape has increased, but convictions have not increased. So there is an enforcement problem. And then there's also an acknowledgement problem. So while if the High Court has given a judgment, there may be 2-3 different views. The Supreme Court might also have several different views. So the district judiciary is not sure which view they should subscribe to. But there are many issues and areas where the views are very clear. But you don't see courts following it. You don't see lawyers citing the law. So maybe we need to think about this as well, and we need to talk about why our judgments aren't being enforced. Why is it? I mean, I'm not just writing it for the sake of filling up paper. There is a whole reason why I'm writing it. There is a whole reason that someone has come to me and sought their rights. So why is it that my judgment is just on a piece of paper and I don't see it being enforced? When we've said a woman is entitled to inheritance in any circumstances, why isn't she given her inheritance? When we've said that a woman can ask for khula and doesn't need to explain it, why isn't she given that khula within 3 months' time? Why does it drag on for a year or 2 years? So we have to ask ourselves these questions, and I think first and foremost, we as members of the justice sector should ask ourselves. The second part of the gender perspective, which I think is vital and critical, is the language that we use. It's very important for this sector to look at the language that it uses. Our language, I'm sorry, but it's very harsh. It's very, very harsh on women. We don't even know how to address our women, and the only way we know how to show respect to our women is by equating them to our mothers and our sisters and our wives. Well, I don't need respect because I'm a mother, wife, or someone's sister. I need respect because I'm Aisha Malik. That's it. That's the only reason. So writing is very important. The language that we use is very important. The manner in which we tell the story, the vocabulary that we use is very important. The adjectives that we use is important. And most important, if we keep using the masculine pronoun for everything, policeman, chairman, if everyone is a man at the end of the day, then the gender perspective is again lost, because you keep perpetuating the same stereotype that everything comes from a man. I make a conscious effort in my judgments, and I've started using they, or else I use the title so that I don't have to use the he or she pronoun. But that's just my effort in order to get away from making my judgment look very masculine. So writing is important. Then the speech that we use is important. And we heard Sana today tell us how speech matters, how words matter, and how we can be very cruel with the words that we use. But as lawyers, as prosecutors, and most importantly, as judges, we have to be kind with the words that we use. We have to think about the words that we use, because it's the words that get her justice. It's not that judgment and me saying she's entitled to, the right to dignity, but it's the way I say that she's entitled to dignity, that I first give her dignity before I can expect anyone else to give her dignity. So I think as you talk through your sessions today, it's important to think about these problems. Most important is what everyone has been saying this since morning, the victim's perspective. This is very important. It all follows in with the gender perspective, the language, the victim's perspective. And unfortunately, our system, particularly our criminal jurisprudence, is geared and fixated on the accused. We think about the accused's right, but we don't think about the victim's right. But when it comes to women and gender-based violence and issues pertaining to women, we must think of the victim. We must think of the difficult circumstances in which she has come to the court, what she wants from the court, what she is trying to tell the court. And I often tell my children that there's a difference between hearing someone and listening to someone. So we really have to listen. We don't have to hear them, we have to listen to what they're saying so that we understand what they're saying. Now let's move on to something that you're going to be talking about, and that is representation of women in the judiciary. You've heard the figures. And I think there's no secret now, we're really lagging behind. It's really sad to say that it took 75 years for a woman to come to the Supreme Court. That's a very long time. We were the last country in Asia to bring a woman to the Supreme Court. And in our high courts, there are only 5. I think that's also extremely sad. When I was appointed to the High Court, I was the only woman there, and I was the only woman there after some 20 years. And when I left the High Court, I left one colleague, Alia, and she's still now the only woman there. So I think this is very important. In the district judiciary, while the ratio is better, I think it's important to recognize that women in the district judiciary fall behind when it comes to leadership positions. They fall behind when it comes to responsibilities. They fall behind when it comes to discussions and decision making because they're not included. And I think it's important now to start including women, start discussing with the women so that you get the larger perspective of what to deal with and how to come to some conclusion. As an institution, this is the response that we need in order to be inclusive. So maybe women are not in the decision-making forums on those tables, but nothing is stopping the decision makers from reaching out to the women. Nothing is stopping them. Nothing is stopping them from saying, I have to take these decisions, so what's your take on it? What's your perspective? What can I do that will make a difference, that will make me more inclusive? Nothing stops those people. So to the decision makers, this is something you can think about, reach out and ask the women and ask them what they need or how they can, in whatever given situation, particularly when it comes to representation of women in the judiciary, ask the women to point out where there are other good women who are good for elevations and appointments. An effort is required, and more than an effort, I think what has to be done is now we have to have concrete plans. We must have plans, actionable plans, or actionable agendas, and then we must monitor those, and we must report on those, and we must say that, listen, this is what we said when we attended this symposium, and now 6 months down the line, these are the concrete steps that we have taken. Otherwise, next year, we'll be standing again at some symposium, and Justice Shah will again be repeating these figures, and they'll be updated, and they'll be even more dismal than they are now. Because we really need to ask ourselves, why aren't women joining this sector? What is it? I've been in the sector 13 years, and a challenge it has been. There's no doubt. But it's been a great opportunity. It's been an absolute wonderful opportunity, and along the way, I've made great friends. And most of my friends happen to be my male colleagues. But I tell you, it's really how you present yourself as well to the women out there. It's how you present yourself, how you conduct yourself, and the positivity that you bring to your work. That also makes a difference. So I think women also have to think about how they want to project themselves and how they want to be seen in the sector. So I thought before I conclude and just share a little bit of what I've understood about inclusivity, I'd share some of my stories of why inclusivity matters. And these are all, some of them are on a lighter note, so I hope that you will enjoy them with me just as much as I do. One of the biggest issues for me is my name. So everybody is very confused on how to address me. Am I a madam? Am I a sir? Am I lordship? Am I ladyship? very complicated. Sometimes I become excellency and people don't know how to address me. Well, it's very simple. It's a court. There's a formal language. It's not very complicated. So, there should not be confusion on how to address me. And just like you've learned over years how to address the male judge, please learn how to address me as well, so that we don't get confused. The other issue is how to invite me. So even today, whenever I'm invited to an event with my spouse, I'm invited as Mr. and Mrs. Justice Aisha Malik. And I always ask, who's Mr. Justice Aisha Malik? I don't know who he is. And I don't even take those cards home now because it's embarrassing for me. So just because we're used to saying Mr. and Mrs. Justice Mansoor Ali Shah, I am not Mr. and Mrs. Justice Aisha Malik. My husband has a name, his own identity. So please, when you are going to address me and invite me, please know how to address me and invite me. And while it's entertaining, but for me, 13 years down the line, I feel sad now that, 13 years, and this is how inclusive it is, that the system still doesn't know how to invite me. So, this is also something to think about. And then another one of my, sort of the bane of my stories are bathrooms. How long do we have to wait to get bathrooms? There are no women bathrooms in the Supreme Court building, the lovely building that I work in. There are no women bathrooms in the High Court. So how long do I have to wait before someone is going to wake up and realize that women need bathrooms? It's very simple. We need our own bathrooms, and I urge anyone here who can make a difference in creating women's bathrooms and toilets, please do that, because this is no longer something that I should be asking for. It's just as much as a woman's right. And actually it goes against my dignity now to stand here and say, please build bathrooms for the women in the justice sector. And then, of course, there is the contribution that you can make on the bench. And as Justice Shah said this morning, you have to make your presence felt as a woman. So very often in court, when my colleague is saying something, I'll quickly correct them and say, don't say that, or don't lecture the woman, now lecture the man as well. Tell the husband what he's doing wrong. Don't just focus on the woman. Or, one of my colleagues once in an inheritance case said that brothers, they really love their sisters, so it's okay if the sister gives up her inheritance. And I was like, no, it's not okay. There's no such thing. There's no general rule. We as the Supreme Court can't say that it's okay. It's her right. And if she wishes to give up her right, that's her wish. Then that has nothing to do with us. But we are not recognizing the fact that it's okay for a sister to give up her right in favor of her brother. This is a God-given right, and as a Muslim country, why are women fighting for their right of inheritance? A right that God has given them. Not law, not man, but God. Why are they fighting for it? It's really something to ask yourself about the gender perspective. So finally, before I leave, let me just share a very important study that I came across, done by Harvard Business School on what meaningful inclusion is about. And they've made an inclusivity index. And in that inclusivity index, they include certain features that they say are critical to an inclusivity, to the concept of meaningful inclusivity. And let me share with you what these are. Equality, fair treatment, access, participation, opportunity. These are very different from the factors or the elements that you will hear other people or other forums talk about, such as generally you hear about diversity, inclusion, and equity. Or you'll hear what's called the JEDI, that's justice, equity, diversity, and inclusion. But this Harvard Business School index says, no, you have to look at equality, fair treatment, access, participation, and opportunity. And the reason you have to do this, because the objective or the outcome is what is important. And the outcome are four: respected, accepted, supported, and valued. That, my friends, is meaningful inclusion. So, as I leave, and I think I've been good with the time, for the panelists to come, please think about these things. Think about respected, accepted, supported, and valued. Think about how we can bring that into the system. Think about how we can bring that change into our system. And as I leave, although this was said before, but I want to just say that when we talk about meaningful inclusion, I believe that this is my right to equality, to be treated fairly, to be given equal opportunity. I don't ask for any special privilege. I don't ask for any special circumstances or treatment. I just say, please recognize that my needs are different. And when my needs are different, my requirements will be different. So please cater to my difference. Don't make me feel different. Thank you.
Representation matters, and I must acknowledge that we learn every day what inclusivity is and what representation is from Justice Aisha Malik. Thank you so much, Ms. Malik. Just a while ago, Justice Munib Akhtar, Judge Supreme Court of Pakistan, has joined us. We welcome you, sir. And then Ms. Laurie Antolinis, who is Director INL, US Embassy, Pakistan, and Shannon has also joined us. So we also say welcome to both of you. Our next session is about ensuring representation for inclusive justice, and I would like to introduce the moderator, Ms. Hana Muzaffar, who is Additional District and Sessions Judge at Lahore High Court. She is also the presiding judge of DBV Court and is recognized for her significant contribution to promoting judicial inclusivity and gender equality. With a strong background in law and a passion for, Ms. Muzaffar has been involved in various initiatives aimed at ensuring fair representation within the judiciary. Please welcome Ms. Hina Muzaffar to moderate the next panel, and she will be introducing the panelists. Thank you so much.
Thank you, Shazia. Good afternoon, everyone. It's my pleasure to moderate today's discussion on the timely and important issue, ensuring representation for inclusive justice. The panelists have requested me to a brief introduction so that to value time for meaningful understanding and conclusion, honoring their perspective. To unpack the topic, I would like to take the privilege to welcome the distinguished panelists. Justice Sonataria, Appeal Court, Thailand. Justice Sonataria is currently the Justice of the Appeal Court. Before becoming a judge, she also served as lawyer, a teacher in Southeast Asian refugee camp, and a legal officer in the Harbor Department. She has concluded various research projects on justice reform, child rights protection, gender justice, prisoners' rights, and environmental jurisprudence. I have to make a request to her, to my esteemed guest, to make her way to the seat on stage, but she has already done it. I think she wants to save more time. Thank you. Our next distinguished panelist is Justice Umar Syal, High Court of Sindh. He is a lady-known scholar and a fellow of the Cambridge Commonwealth Trust. He is the Pakistan representative for Trinity Hall College for the University of Cambridge and a member of the research team of the Hauser Global Law School program at the NYU Law School. Currently, he is the member of the syndicate of the University of Sindh and Dadabhai Institute of Education. I am fortunate enough to request this distinguished guest to take his seat on stage. Welcome you, sir. Our next renowned panelist is Justice Muhammad Amin Nawaz Rana, Judge High Court of Balochistan. Justice Muhammad Amin Nawaz Rana, at present, is member of various committees established under the High Court of Balochistan, including the committee which recommends and proposes the amendments in the High Court establishment, and the Rulemaking Committee for submitting draft proposal of High Court Rules and Order for High Court of Balochistan. I place my request to the noble guest to grace the panelist chair, please. Thank you, sir. Our next prestigious panelist is Judge Maria Josefina, Trial Court, Philippines. She has cross-cultural and legal experience, research studies, and lectures on international law with specialized interest and training on human rights, refugees, and statelessness, women and children, and gender in various local and international fora. Presently, she is presiding judge designated family court. She has extensive training in the preparation of the court agenda, legal research, and internal records management of the court. She is the author of various publications, mostly involved women, children, gender, and other human rights issues. She has been awarded various certificates, including the most significant from advanced course of the Hague Academy of International Law in Philippines. I request the esteemed guest to assume her position on panelist chair, which she has already. I welcome you, ma'am. Our next honorable panelist is Ms. Nida Usman Chaudhary. Ms. Nida Usman Chaudhary is an award-winning diversity and inclusion advocate and founder of Women in Law Initiative, Pakistan. Her area of focus includes, amongst the others, gender-based violence, fair representation, and child rights. She won the Global Leadership Award for Women Rights Activism as part of Global Top 50 in Sri Lanka. I request our honorable guest to take her place. Our next panelist is Ms. Rida Hussain. Rida Hussain is a barrister and advocate of the High Court. I welcome you on stage, ma'am. Rida Hussain is a barrister and advocate of the High Court. The focus of her practice is constitutional law and civil litigation and international and domestic arbitration. She writes for Dawn and the News. In 2021, her paper on the importance of female voices in the Supreme Court was published by the Pakistan Journal of Diversity and Inclusion. My disrespected guest has already taken her seat, so this panel will focus on identifying practical strategies, successful models, and recommendations to create a more inclusive and representative judicial system. Panelists particularly they would focus on Thailand's approach to judicial inclusivity, institutional challenges and progress made in Pakistan, and experience from the Philippines on overcoming socio-economic disparities and improving representation at various levels, and highlighting perspectives on systems response to new entrants, accessibility, and acceptability. May I have my seat over there so we can open the discussion? I request the Academy to please help her for PowerPoint. She has a PowerPoint presentation, my first panelist. Thank you. I would like to open the session by asking our esteemed guest, Justice Sanataria, to impart her expertise that how can judicial systems balance addressing institutional challenges and socioeconomic disparities while promoting women's leadership roles and ensuring accessibility and acceptability for new entrants. You got my question, please?
Thank you very much. Honorable Justices, Judges, distinguished guests, ladies and gentlemen, I'm so proud and so happy and so honored to be here. I thank all of you that you make this important event. Let me exchange my ideas with you all and show some experiences from Thailand. So the cases in our courts, so yesterday we talked about your duties, and I think they are the same. So we have facing the same problem, the same similar cases. Now the most, the big number in our cases are the anti-narcotic law. So even women, wives, were arrested with men. So sometimes they did not know anything, but they were arrested, something like that. So many cases, women came to us as survivor, as defender, and as prisoner. So about the women representation in justice system, when we think of the police, it's the red light. So it means even in the police cadet academy, we were allowed to be there for about 9 years. And after that, they banned. No more female students. I don't know why. And, it's like no enough representation in police. But for the public prosecutor and the judges seem to be in the green light. So it means we have more and more participation. And when you talk about the court, we have like different kind of courts, especially the constitutional court. In the constitutional court, maybe only 10%. Sometimes we are in, sometimes not. But in our ordinary court, court of justice, so we are now maybe 40%. So we set up like the modern court for more than 150 years. And the second half, we started with the role of the women. Firstly, we were assigned to be only in the juvenile and family courts. But later, we can do everything as the men can do, And in other independent commissions, there are still so low numbers of women. In the prison officer or, probation or other juvenile court officers, they are increasing. So I think it's really different. About the lawyers, registered maybe like 40% or 30%, but in practice, maybe less than that. However, I think the big success that we have, you can see it, in this picture, 3 of us were and is Chief Justice, Now we have the 3rd Chief Justice, female. And in this October, the next one will be a woman also. So, 150 years, we started second half, maybe 40 years after we started, we became the Supreme Court justices. And last 5 years, we have been Chief Justices of the Supreme Court. And, the left-hand side above, so she was not the Chief Justice, but she was like the first Judicial Commissioner. The first one who dealt with one case that a male judge has many wives. And she talked in the debate, in the meeting, that personal is political. Stop him not to have more wives, something like that. So this is the statement that came from the female Judicial Commissioner. And on the one lady, I cannot do it, but however, the first Attorney General is also the lady with the red. One of this picture, she was the first Attorney General of Thailand last year. And now she stopped her work already. And the next one, I'm not sure. And the blue UN picture, maybe some of you know her. She is the princess of our current king. She decided to study law. She decided to go to Cornell, finish PhD in criminal law. And after that, she became the public prosecutor. She has big role to develop the, sorry. I cannot, sorry. How can I? She developed these rules. If you know the Bangkok rules for women prisoners to protect the right of the prisoner, Princess Pacharakittiyapa was the creator of these international rules, working with the UNODC. It's a pity that now she is in a state of coma. She had brain death, and she cannot work anymore. So that is the saddest news of our country. However, I think we are, sorry, I cannot be good in this. Again, please. So, okay. I just want to show that my experience of, maybe. Okay. Okay, I just want to tell you that we have success in our judiciary, but we still need to learn from you all and try to develop our system. And, okay, I went out to the world, so I saw some, development and something backward, but I respect that in our region, in Asian countries, we learn a lot and we develop together. And you can see maybe our judges here in the near future. You can see maybe in Nepal, you can see Justice Mala might be the first, Chief Justice. She is in potential to be there. Justice Singh in the Philippines, and also Justice Nina, who is not here, in Indonesia, or even our colleague from India. They can be the Chief Justice in the very near future. So this is the progress that we have. So the women quality, so we bring every new thing, innovation and programs, and we have strategy to develop ourselves and also our judiciary. And as you said, as you can see, so we have the Bangkok rules, and also we have Bangkok general guidance to improve our work for the victims, for the defenders, for all prisoners, and also to develop the inclusivity in our system. And I went to Colombo. They also have like declaration how to improve the role of the judiciary. So there are many events to support our work. But I would like to conclude that what is the big challenge that I found is like it's not only the big problem about gender bias, but many active feminists in Thailand, feminist judges also, so they are gender friendly, they understand, they have gender lens, but sometimes they are biased in other things, For example, we have now many problems with the political conflicts, and many active women are too conservative in politics, something like that. They hate young people's movement, something. So I think many active judges, so they hate NGOs, They don't know how to work with the NGOs, and they say that, they criticize us too much, so they are not liberal enough. So I think biases can happen around our work. And so I like the challenge that Justice Mansour raised in his book. So it's like we are facing like we are hesitant. We want to go, forward. However, we we are not sure about our future. So sometimes we are afraid of the new things, and then we insist on the own thing, something like that. So I think this is the same situation that we are facing. For example, now we have like same-sex marriage or marriage equality law. It's very new, and how can we deal with this new thing? Support the people, support the freedom of the people. It's not easy if we don't really understand their rights or their sufferings. So I'd like to stop and show you some works that I have done. So I just want to tell our colleagues, especially the women judges, that even you are alone or you work, you must believe in yourself. Even one of you, you can do many things. I travel around the world to talk with the people, to learn from them and try to translate into our Thai culture. So I went to the Philippines. We saw the Davide court. So it's like a best practice at the court there. Justice Davide created. So we asked them to translate his work into Thai books, so that is the violet one. And also I joined some UN Odyssey activities, and then we had like handbook to support women and girls in our court. And also I joined the Judicial Integrity Network, and then so they made a handbook also about the gender-related, issues. And it's very interesting because many men judges join us, and they say that sometimes we set the probation measure even in the states, and then 20 hours public work. So it means they call the young lady to come to their home and service, sexual service to the judges, something like that. So many things happen, and we learn, and about the trial of rape. So the UN or the international foreigners researcher made for us, and then so we exchange our idea and develop. So I call this intellectual integrity. I think we need to learn more and more, new things happen, and sometimes it's very difficult to understand. So my last books that I have done, co-author with some colleagues. So first one is A Good Judge, the blue one. So what do you think about A Good Judge? And then one book called A Good Judgment. This is very interesting because we have many, dialogues among judges. And one question that we ask our colleagues, what is the best judgment that you have read? And then what is the worst judgment that you have read? And unexpected, they answer the same question. The bad and the good was the same. Only, and that was about, we call it the Valentine judgment. So one man killed, lovers, they were medical doctors. A man killed a woman. And then the judgment said, love, the ethics of love. You must respect your partner. So maybe one paragraph about the ethics of love. And then the judges talk about the factual problem and then the legal problem, So when the judges say that it's the best, because you set up first, you talk about the ideal of love, and then you talk about the real situation. And then it was death sentencing, However, but some judges say that it's the worst judgment because it's not our business to talk about the ethics of love, So something that is very important. And my last book that we have done last year was about the judicial objectivity. Judicial objectivity in our, judicial decision-making process. So we think it is very important how to understand our bias and avoid the bias. So I think this is something that I prepare to share to you. Thank you very much.
Thank you. Equipped with the meaningful insight of Justice Sanataria, I would like to ask Justice Umar Syal that what is his perspective of ensuring representation and steps taken by Sindh High Court in that context.
Try to answer that. It's difficult to answer in the presence of two of my mentors here, Justice Malik and Justice Muni Bakhtar, and the towering personality of Justice Mansoor Ali Shah. So, but I'll still take with all humility and respect. You see, I think that after children, women are the most beautiful creature God made. It really, really saddens me to see the hurdles which are created in the progress and assimilating them into our mainstream life by my own gender, primarily. Here I'd, with much humility, make a correction, not a correction, but Justice Shah earlier on this morning mentioned that one lady had come from the Sindh High Court. Slight correction over there that I've always considered a woman residing inside me. So there was 1.5 woman who has come from Pakistan. It just comes out that way. I'm ridiculed for it, but so be it. Again, for the time duration, the Constitution in your Article 34, Principles of Policy, has specifically laid down that women will be brought into the mainstream. If we read the policy with the fundamental rights, especially 24, 25, non-discrimination, inviolability of dignity, so the laws are there, and the laws do not really distinguish between man and woman, even the Chapter 7 of the Constitution, or where civil judges are appointed. What kicks in is, let's call a spade, that it's a misogynistic setup, it's a chauvinistic setup, and it's mindsets primarily that a girl fights throughout since after college and onwards, as to why the representation in the judiciary is very low. Now, enough has been said about mindsets. Some brilliant speakers, much more learned and wiser than I am, have spoken extensively about it, and we all realize that as well. So with that, we have to live with it. It will be an evolutionary process. It will be small steps at a time. And I very, very strongly believe that symposiums, conferences, seminars like the present one contribute dramatically to the thought process. That this particular thought of mine, apart from my own experience, and I recollect Justice Shah this morning saying that he thought it was all theoretical until he started going into it deeper. An exact experience I've been through. I went to Maldives, one man came back another. So it was a conference. Today I spoke to the delegation from Sindh, the sessions judges, the additional sessions judges, and I was very happy to find out that some of them I know are very closed-minded sessions judges and additional sessions judges. They were saying to me that their thought has changed since they've come to the Federal Judicial Academy, and they have been doing this. And really, I was surprised to hear that from some very, very, very conservative mindsets. So these programs must go on, but perhaps we can look at bringing it down to the provincial level and at outer stations where all our benches are in each province. In particular, the Supreme Court honorable judges, when they come somewhere, and such distinguished guests who have come from other countries, it really does impact. So one suggestion towards increasing gender, bringing it to that dream of, my dream is that we should all be gender blind in our selection process. But we still need a long way to go before we come into that equality concept. Now, we cannot go for equality at this time because women have been left far behind because of social, traditional, cultural, religious thoughts. All of them have combined. So that will take some time, but at the moment, if we can look at the situation equitably, that will that might increase representation. A couple of examples before the time runs out, a couple of suggestions. In talking to ladies, young ladies who have come into the profession and who would ultimately become judges, one thing comes out is that their primary concern is harassment, implicit, explicit harassment. That is one very big concern. So, and sexual harassment. Now, they feel that if it's sexual harassment, they've got nobody to go to and talk to. And if they do talk to a person, then that it'll be held against them by a judge or by a colleague. So establishment of sexual harassment cells, I'll only speak about High Court and lower, it should be incumbent that there's a sexual harassment cell which has a committee including Supreme Court judges, High Court judge, the provincial district judge where the incident has occurred, and a member of the Bar Council. I feel that if the girl's name is kept confidential and the proceedings are not adversarial, where you have to bring witnesses and be cross-examined, it will add to reducing sexual harassment, that when a committee approaches that lawyer or judge and says, this is a complaint which has come, we don't need to kill him or hang him, but if a person is at least wary that it will go somewhere if I harass a girl, perhaps it will bring it a little bit down. The other issue, I cannot help it, two speakers, too much distinguished, have already mentioned, is toilets. We actually feel that women don't need to go relieve themselves anywhere. And we've got a principal seat in Karachi, and then we've got 4 other benches elsewhere. Okay, 30 seconds. So wherever I go, I try to make bathrooms. And for females, with the assistance of the bar, because they are crucial for this. And a viewpoint I got from a general secretary of a bar association, who then went on to also come onto the bench, was that why do you keep harping on this? We did open female bathrooms, and you know what? Females were taking men into the bathroom, and they were throwing sanitary napkins everywhere. How absurd is that? It's totally absurd that they'll wait for a woman's bathroom for a girl to go. Sanitary napkins, let alone the provision of an incinerator, which will remain a dream. There are no trash cans. And we can teach those ladies who are doing this. But not to have a bathroom for this reason, not acceptable. The district judge of each district should be encumbered with this, that he has 4 operational bathrooms running, woman by a woman, with a place inside for a girl who breastfeeds. So at least this very minimum. The Judicial Commission of Pakistan, with all respect, very rarely has a woman presence. That's primarily because the composition is such that, apart from Justice Malik, nobody has come up as yet. But perhaps that one member who was taken as a senior judge could be a retired female judge of the High Court. I know it's not the court which will do it, it is the Parliament. But thank you so very much for listening. Thank you.
Thank you, sir. But you can take 1 or 2 more minutes, because you have cut short your brief if you want to.
Yeah, then the other thing which comes up is that we must also introspect ourselves. At the end of the day, it is us who's been a member of the judiciary everywhere, and where we are, that we don't have bathrooms. So perhaps some introspection is required, that are we ourselves guilty of that bias we speak about and preach at different levels? Some examples, apart from the bathroom, comes in is a colleague of mine I sat on the bench with, who a 12-year-old, a 13-year-old getting married, and I ended up into a tiff with, not a tiff, but a difference of opinion. And I was told that it's fine if a 12-year-old marries, it's okay. So, while respecting the other person's viewpoint, one must look at if you see the definition of kidnapping, it means a minor with or without consent getting married. Sindh has been hit by elopement. every day, without exaggeration, I would say about 50 cases of what is being called free will marriages are being initiated all over Sindh. Every day, a girl running away with boy. Now, my own colleagues look at it with the mindset that this is fine, she's getting married, not looking at what kidnapping entails, not looking at this is the law which has to be followed, whether you like it or not, and thirdly, not looking at the trafficking provisions. A lot of these girls are being trafficked, and the normal modus operandi being that a girl, boy come to the High Court, say, there's a FIR registered against me by my parents, I have married with my own free will. The judge does not bother to even ask her, are you 18, how old are you? And passes an order saying that, oh, the police shall provide protection, no arrest on the FIR, everything. Without considering that it could be kidnapping, without considering that maybe this girl is being taken to be trafficked. So the girl, once she's at the High Court and gotten an order that oh, everything is fine, she's got parents who will kill her if she goes back. Not every parent is so enlightened and understanding taking back. She wants to go away from a husband who has put her into prostitution or has trafficked her. But the husband has a nikah-nama, a free will marriage, and a letter and an order from the High Court as well as the Sessions Court saying that she's married out of her free will and she's very happy. Where does that girl go? All doors are closed for her. So this particular sensitivity must also come. Last suggestion, you've been very kind to give me a little bit more, that perhaps we should also get the 5 most senior judges of each High Court to come to seminars, symposiums such as this, because at the end of the day, a judge junior down on the line may think differently, but will not be able to implement women's representation changes. So if those 5 come and at least 2 or 3 can change their mindsets in thinking, we might progress further. Thank you very much. Thank you.
Moving on, sir. Now, I would like to seek input of Honorable Justice Muhammad Amir Nawaz Rana on the aspect that how women participation and how women participation in Balochistan is perceived, and what are the socio-economic issues faced in Balochistan.
Honorable Judges of the Supreme Court and Honorable Judges of the High Court, ladies and gentlemen, good afternoon. Thank you very much for having me. Yes, perception is the issue, and sometimes wrong perceptions does cause a lot of misunderstandings. My presentation is there. In that case, that is there.
Please come here.
While sitting here and listening to the speakers since morning, so evolution of my own thought is going on, and how we living at Balochistan, how we perceive things, and how at Islamabad openly these topics are being discussed. Probably we are not having these discussions going on in Balochistan in different courts. And 525 female lawyers are there, registered female 555 lawyers, but just 25 or 30 they are practicing. Why 500 are not there? This is a big question. And before coming here, I had interactive section and I asked them. So they said that there is no conducive atmosphere. We feel though safe in courts, but not safe in the lawyers' chambers in evening. And they had certain issues, and being I think I'm judge for last 2 years and lawyer, quite busy lawyer. So I didn't have their perspective that why these girls every year they're coming and leaving the profession. So this symposium provided us the food for thought. And while sitting here, and since Aisha is here, she's a role model for them. So I remember a story from my childhood days in school. We used to go there and a teacher used to give us topic every day, every weekend, and we had to speak about it for and against. So once we went there, the teacher wrote a topic. It was a famous line of Shakespeare from Hamlet, Frailty, thy name is woman. So we had to speak. in favor or against. So I stood up, I said, no, I want to speak against it. It's not right. Shakespeare was not right. And teacher asked why. So I told him because Shakespeare probably didn't know my mother. If she had known my mother, he would not have written this line. Today I say with some addition, if Shakespeare had seen Justice Aisha Malik, he would not have dared to write this. And she is a role model. And since her elevation, I see a change in female lawyers. Now they see we can make it to that, to that highest forum. And if she can do it, so they can also do it. So I see a certain change in there. Second, when we talk about perceptions, yes, that's true. Certain professions have perceptions. Like if you, there's activity in school. Children have to draw pictures. If you tell a kid, draw a picture of girl, a farmer, a military officer, the kid will draw a picture of a girl, the picture of a farmer with turban, a picture of a military officer with mustache, with big mustache. So it's understood that a farmer has to be a male, a military officer has to be a male, and I don't know how many journals we have a female, if anybody has that idea. I just think just one, and she was from medical corps, and I think inclusivity, it should be in every department. So, that should be there. So when we go to historical approach, you ask question with regard to, is it working?
Yes.
It's not working. Historical and global perspective. When we have to see our country in historical and global perspective. And three countries I have picked: United States of America, United Kingdom, and India. Supreme Court was constituted in USA in 1790, I think, 1719. It's been 236 years. In 236 years, there were 115 male judges, just 6 female judges, and 4 female judges are in current Supreme Court. So in past 200 years, there were just 2 female judges. And then in United Kingdom, it's a newly constituted Supreme Court after House of Lords separate committee. Since 2009, I'm currently out of 12, there are 2 female judges. In India, there are 34 Supreme Court judges, and 3 of them are women. So we are also gradually and slowly working on it and considering our cultural and religious and, should I say, misinterpreted religious principles. There are certain hurdles, perceived hurdles, which in fact are not there in religion. If you go through the work of some scholars, so they are highly misconceived perceptions which are there. Now, I just want you to read this excerpt from the judgment of a Supreme Court. The paramount duty, the paramount destiny and mission of a woman are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator, and the rules of civil society must be adapted to the general constitution of things and cannot be based on exceptional cases. I showed this excerpt to my colleagues, and they said it may be Supreme Court of Saudi Arabia, maybe Supreme Court of Iran, or maybe Supreme Court of Afghanistan. But this excerpt is, for your surprise, from Supreme Court of United States of America. And that is Bradwell versus Illinois. Bradwell was a female lawyer who got the license. She wanted to practice. She was stopped by USA system. And she filed petition, and her petition was dismissed but in the year 1873. So they have evolved. They have evolved by the time. And you know that till 1919, women did not have the right to vote in America. Until 1928, women did not have the right to vote in UK. So things are, how quickly things change. I'm giving you these statistics so we can understand that we can also change. It's not that we are cling to something old. Now, second is, excuse me. ये वाला. Excuse me. Please, चलाएं. It's definitely चलाएं. I mean, giving this example from Pakistan. 3 times, yeah, thank you. 3 times, Federal Shariat Court of Pakistan was approached by different petitioners to get ban upon women induction in judiciary. The initial case was famous Insar Barni case versus Federation of Pakistan, reported as 1983, PLD 73. A very detailed judgment was there, and from Islamic principles, from Quranic verses, the Federal Sharia Court held that it is not un-Islamic. And I think it's not been reported. Then second is Mia Hamad Murtaza, and third one was recent, I think PLD 2023. 3 times when women were inducted, this Federal Sharia Court was approached in Pakistan that their appointments should be cancelled each time. Compared to what Americans were doing, our Federal Sharia Court said that it is in accordance with the injunctions of Islam, and women cannot be denied this right. So but if you go to Balochistan, you go to KP, they are having, I don't know what sort of Islam, what sort of interpretation they have. They have their own interpretation. So that is causing hurdle. Then we have the opposite side. What should be the judiciary? I mean, it's Madam Justice Liana Leach from Canada. Justice Shah in the morning explained how Canadians, they are working on it. So she said, an excellent and meritorious judiciary should be just as diverse and inclusive as the country that it represents. So this is the idea. Now, institutional challenges, socioeconomic disparities, barriers in access to justice, women's representation in judicial leadership roles. We need to change mindset. And in order to change mindset, I mean, Dr. Adila said, the main thing is to change mindset. Laws cannot change this disparity. Mindset can. So she said that we should acknowledge differences. We should greet differences until differences make no difference. Okay, way forward, the interactive session I had with my female judges at Balochistan and female lawyers, so this is the outcome. The main thing is money makes the mayor go. We have to make the posts attractive. The female judges are saying that we are unable to make both ends meet if we go too far, districts from Quetta. So it's not possible for them to survive, to take care of the children. There are not good schools. Naturally, if a female judge is there, she has children. So in Balochistan, only just Quetta. In Punjab, you have every city, you have all the facilities. In Quetta, you cannot think about basic facilities apart from Quetta. You go to Sibbi, you go to Gwadar, you go to Turbat. At Turbat, we have High Court bench. At Sibbi, we have High Court bench. Absolutely no basic human needs are there. So how can we expect that our judges, they would go to all those far-flung areas and they would perform when there are no basic life? So what were the suggestions? That raising the standard of education in law colleges, we have to do it. If we need good female lawyers, providing career consultancy to female students in law colleges as per requirement of the commercial market, creating more opportunities for female lawyers in the judiciary as well as in other departments, including but not limited to legal consultancies. Stipends we pay. This is important. All of them were saying, sir, this thing, that for all the new female lawyers, stipends we pay to new interns for at least 2 years. They come out from the law college, they have absolutely no clue where to go. They are asking different people which office I should join, where should I go, and then they are exploited sometimes, unfortunately. And law clerkship program, as we have in Supreme Court, that same law clerkship program we started at the High Court level. And I was just going through the Indian Supreme Court, sir. Recently, I think last month, have given the judgment that there should be 1/3 representation of women in the Supreme Court Bar Association. They have given this judgment last month in order to ensure the women representation, and the post of treasurer, and that is very important post in Indian Supreme Court, has to be for women. Only women candidate can participate in that election. So this kind of participation through judgment, they have done so. watching. Okay, now, my daughter gave me this, so I'm sharing it. And it's your road for all the female lawyers. It's your road and yours alone. Others may walk it with you, but no one can walk it for you. So my daughter was preparing this, these slides, so there was women participation in making these slides also. Thank you very much. Thank you very much.
Thank you very much, sir. At this moment, I would like to request our distinguished guest, Judge Maria Josefina, to enlighten us with her perspective that what specific strategies or models have been effective in increasing inclusive representation in the judiciary, and how can these be adapted and replicated in other contexts. Please ask the ma'am if you want to have the mic. You got it. Okay, fine. Yeah.
Good afternoon, everyone. Your honors and colleagues, esteemed colleagues, we'd like to, on behalf of the Philippine Judiciary, we'd like to thank the Supreme Court of Pakistan, the Federal Judicial Academy of Pakistan, and the UN Women Pakistan for inviting the Philippine Judiciary to give us this platform to share our experiences, lessons learned, best practices, and ways forward in terms of gender mainstreaming in the Philippine Judiciary. I have a lot of slides, but I'll really try to breeze through it. In the Philippine context, we have it in our Constitution. The state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. The Philippine Women Judges Association has been a formidable game changer when it comes to gender mainstreaming. We have also been affiliated with the International Association of Women Judges. We have the Court of Appeals Associate Justice, who was the first Filipino IAWJ president in 1994. Then we have Chief Justice Teresita Leonardo de Castro, who was the first female Chief Justice of the Supreme Court and the first female Justice of the Supreme Court of the Philippines to have become the IAWJ. And as I said, the Philippine Women Judges Association has been a collective game changer to mobilize support for women's rights, promote solutions for promote solutions to gender bias, and propose solutions to gender inequality. Some contributions of the PWJA in the delivery of justice. We have the mandatory continuous trial, especially for family court judges, the black robes for women judges, black robes for all judges, and the introduction of technology in the court. Women representation in the Philippine judiciary. This is our present composition of the Supreme Court. We have 2 women justices in the Supreme Court, the 15 incumbent justices. That's the 15 complement. We have Justice Amy Lazaro Javier, who is now the president of the Philippine Women Judges Association and the vice president of the IAWJ. Then we have Justice Maria Filomena Singh, who is also a good friend of our esteemed Justice Shah, and who is now the executive vice president of the PWJA and the regional director for the IAWJ Asia Pacific. This is now what you can see is a composition of the male and female when it comes to appellate courts. Interestingly, we have 3 collegiate appellate courts. We have the Court of Appeals, which is an appellate court of general jurisdiction. And interestingly, we have 30 women justices out of 68 incumbent justices. But we have a female presiding justice. In the Sandigan Bayan, we have 9 women justices out of 21 incumbent justices, and we have a female presiding justice. But for the Court of Tax Appeals, we have 7 women justices out of 9, which is quite interesting, very high. But the presiding justice is a male justice. For the first and second level courts, and I am in the second level court, which is, I think, to my mind, is the equivalent of your district court, we have 44% men, and women judges 55.6, 56, which we are proud of in terms of the first and second level courts. But as we go up to the higher echelons of the judiciary, that is where it's dwindling. All right. And with that, the Chief Justice now, Chief Justice Alexander Hesmundo, has realized the importance of gender mainstreaming in the judiciary. So the Supreme Court now has come up with a strategic plan for judicial innovations, a 5-year plan, and we have given some, Justice Shah, a copy of that, a printed copy of that. And this was introduced through the leadership of Justice Hesmundo. It's a blueprint of action for judicial reform, and it aims to achieve the aspiration of delivering responsive and real-time justice. Among these guiding principles are timely and fair justice, transparent and accountable justice, equal and inclusive justice, technology adaptive justice. And also one of its outcomes is access to justice. This is a very interesting legal feminism study in Philippine gender jurisprudence. This was prepared by Supreme Court Associate Justice Singh, and we'll be very much willing to share with you this entire study, because this was really the platform when it comes to gender mainstreaming in the Philippine judiciary. I'll just breeze through the slides, but we will be sharing with you the study on this. So it involved a review of 153 Supreme Court decisions from 2006 to 2022, focused on 7 key areas: gender fair language, marriage and family, LGBTQIA+, rape, violence against women and children, and sexual harassment. Just to focus on that, according to Justice Singh, we cannot achieve gender equality without first having gender sensitivity. I'll just breeze through that. And the PWJA and the gender revolution in the Philippine justice system. How did that PWJA, as a collective game changer, what have we been doing? So we have the Bangkok General Guidance for Judges in applying a gender perspective. We have the National Judicial Dialogue on Access to Justice for Women with development partners. And then we also have annually the celebration of the Women's Month in March and the International Day of Women Judges. And in this month, we all wear the color purple, which is supposed to represent women. So we do this for the entire month of March throughout the entire judiciary, including court personnel. Then we have also the annual celebration of the Pride Month in the month of June. This inclusivity cuts across all genders. Again, it's also mainstream throughout the entire judiciary, not just for judges and justices, but also for court personnel. The Her Story Award is a gender award of distinction. This is an annual campaign, a search for women, lady judges and justices, their story on how they were able to break the glass ceiling. We want to sustain this Her Story campaign, which I think also is an equivalent of what you're trying to do now in terms of the gallery of women champions. And what we want to do is to be able to expand the visibility of women judges and justices in order to counter whatever gender bias or gender prejudices that the society may have, and in order for us to be able to push the boundaries and be able to campaign for more gender parity in the higher echelons of the judiciary, especially for the appellate courts and the Supreme Court. We have the link here. I will be able to share the PowerPoint with you. The co-impact program of the IAWJ and PWJA, we have not only been trying to advocate this among lady judges and justices, but we've also been doing that in terms of the correctional facilities. So the lady judges and justices have been visiting correctional facilities and training correctional officers, especially the women correctional officers, as well as skills capacity building, skills training, and the products or output of these women deprived of liberty, we showcase and highlight this in our convention, the PWJA and the IAWJ. So these are just some of the projects. Ways forward, other pathways. We have the mental well-being. We now have a hotline in terms of mental wellness, not just for judges and justices, but also for court personnel. We have the continuing judicial education through the Philippine Judicial Academy, mentoring that was also mentioned a while ago. We have that. Child minding centers, and now we're trying to introduce now technology-driven justice system, including the introduction of artificial intelligence as a tool for research, not for purposes of replacing the human mind in terms of decision making, but only as a tool for research for our court attorneys as well as for the magistrates. Lastly, we have a 5-year program now with the IAWJ. We call it the Women in Leadership in the Law. And this is a 5-year program which aims to promote gender parity, to assess the policies of selection and promotion, especially for the judicial making bodies and commissions. What we found and identified as the bottleneck in terms of the selection and nomination of more female judges in the higher ranks, in the appellate courts and in the Supreme Court, is the Judicial and Bar Council, which is the gatekeeper in terms of selection and nomination of judges. We found out that there is really no gender parity in terms of the composition of the JBC, and what we are doing now is to be able to create a coalition among civil society, the Integrated Bar of the Philippines, and other women organizations to be able to promote gender parity in the Judicial and Bar Council. In that way, we will be able to encourage more transparency in the selection and nomination, as well as be able to have influence more in terms of being able to have gender parity in the selection and nomination of the short list of candidates that will be submitted to the executive department for the appointment of the magistrates in the appellate court and in the Supreme Court. And lastly, we extend the Her Story campaign to advocate the stories, the testimonies of women judges and their divergent career directions. To cap this up, may I just quote from Justice Javier. We may come from different parts of the world, speak different languages, and have different cultures, but our battles are aligned. It is a battle for recognition, for acceptance, for equal opportunities, to be allowed to take up the space, speak up and be heard, to be seen and recognized, and not only to live, but to thrive. We may be exhausted, but we are never defeated. That is our true female resilience. With that, thank you.
Yes, we have got some new eras we can think about regarding our own country perspectives. Now, I would like Ms. Nida Usman to share her vision on current state of representation of women in justice sector and what are the factors that led to it.
Wow, thank you. Hundreds of years of historical injustice, 8 years of research and advocacy, and I only have 6 minutes. I'm going to try my best to make the most of this elevator pitch that I'm asked to do here. The fight for inclusivity, I would say, is a historical one, and I really want to stress on this, that it's not something that has started today. Prior to 1923, women were not even considered as being included within the definition and meaning of the term person, as used in the Legal Practitioners Act of that time. A special law for removal of doubts as to a woman's personhood had to be passed by the legislature in 1923 to enable women to actively practice law in the courts as lawyers. No such special law was required for men. Their personhood and their ability to act as an advocate was never a doubt that needed to be expressly removed. So that's the extent, and that's the struggle, and that's the fight for inclusivity that started from Regina Guha, the time that she first challenged it in Calcutta, and that resulted eventually in the Legal Practitioners Act 1923, an act for the removal of doubts. Now, this morning we heard a lot about the statistics, but before going to that, I want to bring to the attention of this forum that, 101 years have passed since that time when the law was first, introduced. But it took 74 years for a woman to become a justice of the Supreme Court of Pakistan. And for context, we know that we are the last country in the region to have done so. Even Afghanistan had at least 2 female judges in their apex court before we did. So that's something to think about. And, it's very easy and it's very lazy and convenient to assume, as it often is, that the factors behind such disparity are that, there are no qualified women, or that women themselves lack the passion to or the will to advance in the profession. And only if they would put in the same effort as a man or be as professional so as to meet the technical requirements on merit as a man, then surely the system would equally and fully embrace them all as well. Just as it did Asma Jahangir or the others before us. Because we're constantly told that, the law does not distinguish between male and female. If it's a Lawyers' Welfare and Protection Act, it doesn't discriminate against female lawyers. But what they fail to address or register is that how a woman or a female lawyer would identify or define welfare is very different from how a male lawyer looks at welfare and defines it and goes on and finds it in the law. And when that law was being drafted, not a single woman's opinion was taken, and so, as a result, not every day you can have laws being passed from the assembly, but that opportunity was missed because, once again, welfare was that you be appointed to, 3 companies as a legal advisor. What about daycare centers? What about maternity leave and, all those policies that concern our welfare? What about bathrooms, as we've been talking about? So it's very important to have women in these places, in these forums, because that is what happens when you do not include. And it's unfortunate that a lot of my female colleagues also had the same thing to say to me, that why are you criticizing the law? It doesn't say that female lawyers can't be advisors in these companies. I was like, you're just completely missing the point. But anyway, I would say perhaps it is time that the law should distinguish. Perhaps we should also distinguish these finer details which come from the gender perspective, because it is not a time to be gender blind anymore. It is a time to be more conscious of the different needs of men and women for meaningful inclusivity and operative equality, as opposed to just equality on paper. We have to rid ourselves of sameness as a standard, because that is modeled on the lens which is male-centric. And that's where I think I want to talk about the quantitative standards also that come from the colonial times that we still hold so dearly on to. Things like number of judgments and attendance in court, and all of that is so quantitative and so male-centric, because how many female lawyers are sent by the law firms to assist their seniors in the court? They're usually just retained in the firms, if they're given a job at all, to just work on the briefs. And also I think it's time that we sort of reevaluate how we are gauging merit also. It cannot be from a male-centric lens, and we have to look at it just historically tha Mughal daur mein, before we were colonized, things like integrity and character and qualifications beyond these professional metrics were looked upon at. So I think qualitative assessment is extremely important, along with Article 25(3) and 34. So you need to look at that. If you're really serious about diversity and appointing women in judiciary, I think another important provision that is often overlooked is Article 177(2)(b), which allows lawyers with 15 years of advocate high court experience to be directly appointed to the Supreme Court. That has never happened in the history of this country. And the interesting thing is that there's no age barrier here, like you have in the appointments for the High Court provision. So for the High Court, you may not have a woman who's 45 yet, but for a Supreme Court, there is no age limit defined in that article. So why don't you appoint more women lawyers directly to the Supreme Court? But hoga kya? Media wale कहने शुरू हो जाएंगे, they'll start pitching, they'll bring in one judge against the other. There'll be absolutely no accountability for that. And the backlash that will come because of egos that will be ignited and exploited on the social media, where is the accountability for that? If the Constitution allows you to do that and make these concessions, and they're not concessions as they are termed as, these are constitutional guarantees through affirmative action, why are we then afraid to use these provisions and not appoint women who qualify directly? There are some things for which you need constitutional reform, I understand that, but there are some solutions that are present within the Constitution and within the power of the courts themselves, and I think they can do that. Thank you.
Thank you. Being mindful of figures elaborated by Ms. Nida Usman, I request Ms. Rida Hussain to impart her wisdom that what is meaningful inclusivity, how it can be achieved.
Ms. Nida Usman is always a tough act to follow, but I'm going to try and I'm going to do my best. Meaningful inclusivity to me means equality. And I think today we can agree that it's time to change the narrative. It's time to change the discourse. It's not just a question of diversity. It's not just a box-ticking exercise. It goes to the heart of equality. It goes to the heart of the credibility and the legitimacy of our justice system. We've been talking about a gender perspective and what a gender perspective means. And I think in our jurisdiction, there's a perfect example. To come to the Protection Against Harassment of Women at the Workplace Act, this was previously interpreted by a male judge to mean that only harassment of a sexual nature was covered. Harassment, however serious, which was not of a sexual nature, was entirely excluded from the protection of the law. Victims of harassment, which were supposed to be protected by the law, they were excluded because of this interpretation, and it did not account for the fact that workplace harassment is pervasive and it's not always sexual. Thanks to Justice Aisha Malik and her perspective, this decision was ultimately overturned in review jurisdiction, and she held that not all harassment is sexual. There are different types of harassment. And this is what we mean when we talk about a gender perspective. You need to let women into positions of power to challenge these stereotypes, to challenge these assumptions, and to break these barriers. There's a lot that we've talked about in terms of mindset. Domestic violence still considered a private family issue. When we talk about sexual violence, rape, we've talked about how women's character is questioned. What was she wearing? What was she doing there? Why was she there? It's irrelevant. Our courts have said it's irrelevant, but still this is something which is done. We need to get women into the justice sector. How do we do it? We have the Judicial Commission of Pakistan. It's been said it's a body that comprises entirely of men. The very body appointing judges is an all-male body. The Attorney General, a man. The Law Minister, a man. The Chief Justice of Pakistan, a man. The 4 senior-most judges, men. Even the retired judge on the Judicial Commission of Pakistan is a man. We need to make the Judicial Commission of Pakistan more representative. The Judicial Commission of Pakistan also needs to be more transparent. It's very opaque. There's a lot of secrecy which governs it. As part of the Women in Law Initiative of Pakistan, we've also advocated against the seniority principle. Why? Because seniority hurts women. When you insist on seniority, you ignore the fact that women are excluded, and the structural inequalities make it easier for men to rise to positions of seniority. It allows them to get to those senior positions far easier than it is for women to get to those senior positions. And now we've heard that the Judicial Commission of Pakistan has amended its rules and included diversity and inclusion as part of their criteria. And we would urge that this actually be implemented, because when we look at judicial appointments, and if we look at the more recent judicial appointments in our own Supreme Court, they haven't been inclusivity focused, they haven't been equality focused. And I would entirely endorse what Ms. Nida Usman is saying when she says that we need to consider appointing female lawyers directly to the Supreme Court as well, because this is something that our Constitution allows. And I also want to talk a little bit just about the role of the federal government. And we have federal government representatives that come to these conferences, and they promise inclusivity and they promise representation, but they do not follow through. The federal government constituted a committee for legal reforms. It was an all-male committee, a committee that comprised entirely of male lawyers. In 2024, the federal government still does not think it's necessary to include female lawyers on these committees. And now you have the federal government and their representatives saying, we are going to amend the Constitution. We will amend the article of the Constitution which relates to judicial appointments. How can you have an all-male committee of lawyers looking at these articles? Women will be impacted. We have never had a female Chief Justice. If you are amending the Constitution, you need to include female lawyers as part of these conversations which you are having. And we've talked about the mindset, and this is also something that we need to confront head on. You have lawyers, top lawyers of this country writing articles saying that women get married, why should we invest in them? Women can't stay in law offices till late at night, why should we hire women? And you have them perpetuating a patriarchal mindset. They don't take women to court, they give women office work, they give women research work, and they also further this patriarchal mindset. Justice Aisha Malik said that why do male lawyers not address her properly? They would never do that with a male lawyer. Male lawyers are always their lordship, and with women, this is how they are addressed. Even in the lower judiciary, there's lawyers misbehave with women, and this is not something that we consider a serious matter. They misbehave with female judges, and it's not something that is taken seriously or considered. So it's this mindset which needs to be changed. It's this mindset which we need to confront head on. And it has been said that it took Pakistan 75 years to have a woman at the Supreme Court. We cannot wait another 75 years for equality. We have to act now, and we have to act fast. Thank you.
Thank you.
Paying my heartfelt gratitude to the prestigious members of this session, thank you all for your valuable input. Over to Ma'am Shazia, please.
Thank you so much, Ms. Rida, you just spoke my heart out. Thank you so much. I think to say thanks to all the panelists. Please resume your seats. Thank you.
Now I request Mr. Fakhar Zaman for his takeaways within 1 minute. You have 1 minute, sir.
Honorable Sir, I have been given 1 minute, so it should be crisp. And still some distilled wisdom. Overcoming institutional challenges. There is a need for strategies such as policy reforms and training programs to address systemic barriers within the judicial system. Next is thanks to Honorable Justice Malik, the meaningful inclusivity as distinguished from inclusivity. And again, a gender perspective, a strict adherence to gender fair language and inclusive language. And then thanks to Suntaria, judicial intellectual integrity, that we must practice what we preach. And then addressing socioeconomic disparities, there is a need to highlight the impact of socioeconomic factors in access to justice and recommended targeted initiatives to bridge these gaps. Improving access to justice, there is need for practical measures like legal aid services and community outreach programs to enhance accessibility for marginalized groups. Promoting women's representation in judicial leadership roles. There is need to emphasize the need for mentorship programs and affirmative actions to increase the number of women in the leadership roles within the judiciary. Thank you very much.
Thank you so much. My profound thanks to everyone, especially Ms. Fozia Bakar, who joined us after the lunch. And my special thanks to Ms. Huma Mansoor for gracing us with your presence at the Symposium on Inclusive Justice. Your support and commitment to this important cause are deeply appreciated, and we are honored to have you as a part of our community working towards a more just and equitable society. And we are looking forward to it, that you are joining us tomorrow as well. Honoring us with my last word is, honoring us with his spouse shows Justice Shah's commitment and sensitivity towards inclusivity and representation. Thank you so much, Justice Shah. A big clap for Justice Shah, Ma'am Huma, and Justice Aisha, Justice Munif, Fozia Bakar, Ms. Laurie, and all the delegates. Thank you so much. Now we have a tea. and we have to vacate this place as early as possible because they have an event. Thank you so much. I'm sorry for the panelists. I could not give much time. Tomorrow we are assembling in Shamadan Hall. It's not the same hall. Thank you so much. Shamadan Hall.